when it is taken up, yes.
My lord, serial number 41, my lord, I appear for the appellant. We have engaged a senior counsel in this matter, my lord, and he has some difficulty today. Maybe taken up next week, my lord.
Even otherwise, there is a delay of 41 days.
41, please, my lord.
So
There's a
it can
delay
be
of 4 days.
notice to the respondent.
The notice was issued in the last hearing date, my lord.
Notice is issued. All right, then it will go to 6th of February, as requested by learned appellant on the ground that counsel who is appearing has some difficulty in conducting the matter today. Yes.
Please, my lord.
Can you mention through EC, sir? The contempt matters, this one, still number 1, Vaibhav M.
I request the petitioner. No, this is a matter where an FIR came to be stayed by the single judge, my lord. Despite that, the accused has filed charge sheet, my lords, while the interim order was subsisting. At page number 20, my lords, is the interim order.
So investigation was stayed.
Yes, investigation was stayed. And the charge sheet came to be put up on 28/11 at page number 78. my lord.
File your counter. What? You file some counter.
I filed here in this case, what has happened? On 10th, my lord, the matter came to be stayed. On 10th, the matter came to be stayed.
Matter came to be
Stayed.
10th.
On
Yes,
10th.
on 10.
10th of
10/11,
11,
2023.
23.
10, 11, 20.
23. My lord, on 11th, Lord, may kindly come to page number 46. Next step, please. I moved from Lord an application before the Honorable Magistrate Court. And Lord, an order came to be passed now, page number 48. The requisition given by the PSI of Velanduru Police Station by name Yogesh is hereby allowed on the following conditions, and he is permitted to register the case and investigate the matter. This, my lord, is on 11th, that is on the very next day.
11/9, my lords. This is 11/9. They're misleading the court.
11/9.
Yes, 11th.
It's 11/9/2023. The interim order is of the date.
Subsequently, I'm sorry, my lord, the interim order is subsequent. My lord, after that, my lord, the message, my lord, on 10/11 has not been communicated to me at all.
Order.
It was not communicated to me at all. I received the communication only on 14/12/2023. In the meantime, my lord, before I received notice of the order, I have filed the charge sheet. That's at page number 70.
It's submission
Which-
might
which-
not hold.
On which day charge sheet was filed?
20.
Charge sheet was put up on 28.
11.
26/11.
26/11. I received the communication of the interim order on 14/12.
Put it on affidavit.
Yes, sir.
My lords, I will just make a small submission on that front. The first and the foremost, my lords, at page 121 of the petition, my lords, this is the police notice that was received under section 41A on 29/10/23. It was received through WhatsApp. It has been recorded by the accused herein. Now, my lords, to the same number, the interim order was communicated. That is available at page number 67, my lords, on 10th November 2023. Page number 67 is the WhatsApp this thing, my lord. 68 on 10th November 2023. It was communicated to them, and my lords, my submission is it is not the accused response, I'm sorry, the complainant's responsibility to intimate the interim order, because HCGP has already taken notice at the first instance, my lords. However, on 10th November, the interim order has been intimated. So therefore, to come in,
But here in this case, not. The message, my lord, at page number 71, says delivered, but it is not seen.
that is not my problem.
It's not seen. And my lord, these messages get automatically deleted after 24 hours.
Appears to be, you file a reply.
And well,
Appears to be serious because
my lord, here, my lord, it has not been seen. And my lord, these messages get automatically deleted in 24 hours. My lord. That's because the number of messages that can come to the police officer.
Lords, but if a
Yes,
notice
but
is sent through
hence,
WhatsApp,
my lord, that
they cannot
automatically
take this ground. And HCGP has taken notice on the same day. There is communication of that order. That is for them to respond.
at least henceforth from onwards, don't
Yes. Yes.
ever file reply. When shall reply? 9th of January,
Yes.
Grateful.
Great.
in order to enable the respondent to file a reply.
Waiting for the petition. My lord, the complainant before this honorable court is a father longing to see his daughter.
Hmm?
The complainant before this honorable court is a father longing to see his daughter. And this is in violation of the memorandum of settlement that has been arrived between the husband and wife dated, my lord, 24/8/2023, which is a part of annexure A. My lord, at page number 28 of the petition.
28,
28, my lord, a part of annexure, as a part of annexure A, the memorandum of settlement has been produced. My lord, as per this, may I, my lord? As per this memorandum of settlement, certain obligations have been cast on both the husband and wife, in which, my lord, as per the memorandum of settlement, the marriage has come to be dissolved. 1.7 crore was paid as alimony. Apart from that, a particular flat that was sought for by the mother was also transferred to her name. Subsequently, my lord, the custody is with the mother. The visitation as such, my lord, was prepared gradually in such a manner that the child is able to acclimatize to the changed situation, in which the father had been granted about half an hour video calls every day. He is also been granted, my lord, that he can spend the time with his daughter for the next 2 months, about 2 to 4 years, 2 to 4 hours every month on the last Saturday and Sunday. None of these obligations that were supposed to be performed, discharged by the mother have been carried out, my lord. After benefiting from the financial, after accruing all the financial benefits, she's not been following any of these. And therefore, my lord, we are before this honorable court.
where are the directions?
My lord, it's a part of the memorandum of settlement. My lord, if this honorable court may kindly look into annexure
Correct.
A.
Where is about that video calling, etc.?
My lord, if I may read, my lord, at 2B,
2B,
at page 28, my lord, page 28, part of the memorandum of settlement, internal page number 2 of the memorandum of settlement. The respondent, may I, my lord?
ah, 20, it is page 27. Respondent and his family shall be entitled. Same?
My lord, the
Respondent-
respondent shall have visitation in the following manner.
Respondent and his family
His
shall be
family, Yes, my lord. Shall be entitled to have a video call with Ms. Prerna Vivek, that is the child, my lord, commencing from 8th September 23 for half an hour for 2 days a week, that is Tuesday and Thursday between 6:30 and 7 p.m. and longer calls on weekends, 10 to 11 a.m. on Saturday. The respondent shall provide Ms. Prerna Vivek with a device which will enable her to have video calls with the respondent. The petitioner shall ensure that Ms. Prerna Vivek has access to the device and is familiarized with the functioning of the device for the video call and shall ensure that the device is switched on and the video call is facilitated.
You are for husband,
For the father.
father. Notice returnable. Only 10th January.
Bill number 3, Mr. Suresh Kumar.
Complaining, my lords. And before this, your lordship, wherein undertaking was given by the respondent, is arising out of a conviction in an NI case on a Negotiable Instruments Act case, wherein the respondent was convicted to pay a sum of rupees 55 lakhs. He went in first appeal. He lost the case and the revision was preferred before this honorable court. He gave an undertaking, my lords. We had scaled down from 55 lakhs. We entered into a compromise and we allowed him to pay 39 lakhs. He filed an affidavit, a joint affidavit, undertaking that he will pay the money. In spite of that, he has not paid the money, my lords. He has to pay a sum of rupees 9 lakhs. Out of 39 lakhs, he has paid 9 lakhs. The lordship may please to see Annexure A, my lords. (2011) 2023.
IA for extension of time is already pending.
My lord,
Page 37, learned counsel with the petitioner accused has filed IA number 3 of 23 to extend the time to deposit.
my lords, there is a, no, my lords. Subsequently, on 7/2/2024, my lords. Before that, on 2011/2023, may I read the order, my lords, of Honorable Justice Kazi. Both petitioner accused and respondent complaint represent,
The
both
contempt-
learned.
The interim, the contempt is alleged in respect of order dated, it is interim order. And the contempt is alleged in respect of order dated.
My lords, there is an order to pay within 4 weeks, my lords,
Where is that?
dated the 27/2/2024 by Honorable Justice Rachaya. May I read that order, my lords?
Page?
At page, ink page 39, my lords. Annexure A, my lords. The first page on Annexure A.
There is no page 39.
My lords, so 9 and 39, I got 2 papers because there was some office objection. It was complied with. Annexure A, my lords.
Order, which is the date of the order?
Date of the order is 7/2/2024. Sir. My lord.
Where is this order? This order is not found in the record. 4 weeks to get, 4 week time is granted to pay the same. That is 9 lakhs. 9 lakhs remaining balance. So where is the direction even in this order?
No, my lords, he has given and filed an affidavit, my lords. Your lordship may please to see the other page. The next page, my lords.
This order, you put your house in order first, then we understand.
Yes, my lords.
This order is not found in record of it.
Yes, my lords.
One which is submitted. Petitioner to put his house in order by producing the copy of the order under contempt and arranging the pages in seriatim. Full stop after the necessary rectification, oblique correction, oblique insertion is made, the contempt petition may be put up on board.
Seal number 4,
Date may be given. 2 weeks after date.
Later, once you do it, it will done.
Date may be fixed
Say
at
it
least
will done to-
January, my lords.
No, why Jan?
Anytime, my lords, 2 weeks.
You do whenever you do, and the next day it will be posted. Once you do, it will be posted.
Much obliged.
seal number,
Once the house is put in order, the registration list the matter.
Much obliged.
seal number 4, Mr. Keshav Murthy B.
This matter, we have filed the compliance affidavit minutes.
Mr. Keshav Murthy. Shrimati Shilpa Rani.
Notice returnable on. You are appearing?
Petitioner, ma'am.
Notice returnable on 6th February.
Seal number 7, Mr. Rahul P.
Or serial number 5 or
Number 7,
Yes.
serial number
Five.
5. Court was not audible, Your Lordship. Serial number 5, Your Lordship.
I will. You are there?
Please, madam, I am there, Your Lordship.
Notice returnable on 6th of February.
But the direction is to not relieve the complaint, Your Lordship, from the service, Your Lordship.
That's good. That's good. So you are relieved?
Not relieved, not yet relieved, Your Lordship.
Then where is the question of filing contempt?
My lord, what had happened is, Your Lordship, they have orally they have submitted that, my lord, not to come for the duty from the particular date, Your Lordship.
All right.
But
notice-
specific order has not been issued to me, Your Lordship.
All right, notice returnable.
Please, my lord.
seal number
Learned
Number-
advocate for the, in 5, learned advocate for the petitioner, Mrs. So-and-so, submitted orally, alleging breach of the order that the petitioner is orally asked not to be permitted on duty. Orally asked that he will not be permitted on duty. Notice written available.
Please.
Question number 7, the Rahul P.
7, my lords, I appear for the complainant, my lords. There's a delay, my lords. In this part, my lords, complainant had filed in suit against the respondent, my lords, the accused. The suit
Delay for what? There is no delay, it is either maintainable or not maintainable.
Plus, what had happened is, my lords, there was an temporary injunction directing the accused not to alienate the suit schedule property, my lords, which was not known to me, my lords. When I had filed for the execution, my lords, it was known to me that he had alienated the suit schedule property, my lords.
So injunction is breached.
Please, my lords. Suit has been partly decreed, my lords.
The order under. 39(2). The order under. Order brought.
Well, the suit has already been decreed.
Of this court is an order whereby the injunction was granted, with an allegation that the injunction is breached. Full stop. The petitioner is remedy available under order 39, rule capital 2A, rule 2 capital A of the Code of Civil Procedure. Full stop. Without expressing anything on the merits of the case of the petitioner, petitioner is relegated to this remedy.
The suit is already decreed, my lords.
Even then they will lie.
And both of them have not preferred an appeal, my lords. Partly decreed, my lords.
Now you are after how many years?
My lords, what has happened is, my lords,
2 years.
I came to know after when I filed for
3 years.
execution, my lords.
2.5 years.
I had not known about the alienation, my lords. When I filed for execution attaching the property, my lords, when I took out the EC, my lords, that's when I got to know that the suit schedule property was alienated.
Will it not be maintainable 39 to even after the disposal? Prima facie it appears. It will last after disposal, maintainable after disposal. It will certainly last after disposal of the suit if the application is filed. Similarly, the language suggests that it will be maintainable even after the. Oh, like notice here the 10th February.
Obliged.
Number 8, Stretcher Muesh.
Appear for complaint, my lord. Well, order dated another day. Already passed out this honorable court. 3.5 hours already completed, my lord. The accused authority not passed out any consequential order. Representation is another B, my lord. 21/8/2024.
No time stipulated in this order.
The order portion another A19, my lord. The order of tribunal dated so and so is
Then order is set aside.
set aside. The government is so and so in subsequently.
So
The
what is the
government order is
contempt?
set aside,
What is the contempt?
my lord.
What is the contempt? What contempt is committed?
Yes, my lord. Representation, my lord. Consequential order is necessary, my lord. Consequential order, representation is another B, my lord.
What is the breach committed?
My lord.
What is the breach committed?
My lord, another B, my lord. Another B, my lord. Representation. Request to implement the final order dated 19/8/2024. Consequential order is necessary, my lord.
Page.
Page, another B, page 22, translation copy, my lord. Subject, my lord.
That is an order. Which is the direction of the court which is committed breach of?
My lord, order is withholding of increment, my lord, set aside the.
Where is that order?
My lord, order is
No, please
passed out
take
by
it.
another.
Please take it.
Order number 19, my lord. Page number 19.
19. Where is the direction?
My lord, direction is This honorable court not fixed time, my lord, compliance order, not fixed time.
Even if there is no direction, but apart from the not fixes.
And in the similar situation, in the same order, my lord, this honorable court passed a contempt order, if time fixed and default final order.
But there is no direction here. Where is the, then it will come to fixing of time.
My lord,
What is the direction you point out first? Otherwise, your.
direction ಕೊಟ್ಟಿಲ್ಲ. Complaints, time for complaints.
Parallel not proceed further.
Time for complaints ಅಂತ ಹೇಳ್ಬೇಕಾಯ್ತು ಹೇಳಿಲ್ಲ ಸರ್ ಅದಕ್ಕೋಸ್ಕರ. In the similar situation, this honorable court disposed my lord. Thank you, sir. This honorable court not fixed a day, not fixed a day. This honorable court fixed in another 6 weeks to comply order. Date fix ಮಾಡಿಲ್ಲ ಅಷ್ಟು. Consequential order is necessary, my lord.
So here there is a direction.
Yes.
Court hereby orders the director of the Karnataka Pre-University Board to promptly and diligently comply with the provisions.
Yes, ma'am.
Where is such any positive direction?
Date fix ಮಾಡಿಲ್ಲ. Impugn order quash ಆಗಿದೆ. Consequential order is necessary, my lord. My lord, consequential order is necessary. My recommendation, my lord, very clear, my lord. Another B, subject request to implement the final order dated 9/8, promotion due to the complaint, my lord. Though because of this order, this application is pending before authority, my lord. Not issued any consequential order, my lord. Consequential order is necessary, my lord. Consequential order is necessary, my lord. Because of withholding of promotion withheld ಮಾಡಿದ್ದಾರೆ ಕೋರ್ಟಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್. A punishment order quash ಆದ್ಮೇಲೆ consequential order is necessary, my lord.
Order of law and single judge dated 9 August 24, which is set, it's subject matter of the contempt jurisdiction of this court. But it says under in its operative course, page 19, 2, 3, 4, there will be 1, 2, 3. The tribunal has set aside not the law and single judge, set aside the order of which was an order. Set aside the what is set aside? Penalty order.
Penalty order, my lord.
Set aside the order of penalty. Set aside the order of penalty. Order of imposing penalty, which was impugned with the tribunal. And further directed that it will not stand in the way of competent authority to initiate action in accordance with law. Paragraph, a bare reading of the aforesaid direction go to show that any positive direction is not issued by law and single, nor any time limit is fixed. Full stop. Paragraph, law and additional advocate, additional government advocate, some of the negotiation. You rightly submit that in the circumstances, no contempt could be said to be committed. On the other hand, law and advocate for the petitioner will submit that the consequential obligation, the obligation consequent to the setting aside of the order of penalty would arise to be implemented for the authority. Full stop. In this regard, it is observed that when there is no positive direction and no time limit is fixed, comma, it cannot be said at this stage that any contempt is committed. It will be open for the petitioner to put the respondents to notice about the obligation to comply with the obligation to act pursuant to the setting aside of the order of penalty by further putting the authorities to a specific time limit for such consequential compliance. Full stop. Thereafter, the remedies of the petition will be open to be available. Full stop. With the aforesaid observations and without expressing any opinion on the merits, the contempt proceeding is disposed of, are disposed of.
Case number 9 to Vijay Kumar.
Appearing for complaining. my lord. This contempt case regarding non-compliance of order dated 8/8/2024 passed by this division bench. Division bench order, my lord. The complainant,
Notice. 6th February.
Case number 10 to Manjunath PS.
Deputy Commissioner in this case had filed affidavit on 4th of December 2024, my lord, where a site has been given considering the application filed in the year 2000. Now, the 2000 application which was filed in the year 2000 my lord, was not supported by the income proof. And now, by way of a rejoinder, for the first time before this honorable court, they have filed their payslip which shows 90,000 as annual income in the year 2001. my lord. Therefore, my first submission is that considering that application in accordance with rule, my lord, Rule 4, which says the annual income should have been 8 to 20,000. So there are two aspects, my lord. One is the application filed in the year 2000 has been revisited pursuant to the direction issued by this honorable court, and a site has been allotted to him subject to satisfaction of the income proof which was not submitted in the year 2000. In the year 2000, Rule 4 says income ought to have between 8 to 20,000. They do not satisfy. I think the respondent will deal.
my
I'll
lord,
just
in
complete,
this?
my lord. I'll just
But
complete.
You are undoubtedly so powerful that they are fighting like it. Now you are coming on the income criteria.
No, my lord, I'm only saying the
Earlier
site,
you said that the land is not available.
my lord,
Before that, you said that the application was below the seniority.
my lord, I have, lordship may kindly take my affidavit, my lord.
My lord,
At page 4, at para 4, I have said treating their application as having been transferred in the year 2019, my lord. My affidavit may be taken. He retired as a circle inspector, drawing 94,000 salary per month, my lord. We are only here to ensure that the proper ex-serviceman gets his due, my lord. Kindly see my para 5 of the affidavit which I have filed. I state with the insertion of sub-rule 8, the Karnataka Land Grant Rules of 1969, with effect from 2/3/2019 and treating the application of the year 23rd of May 2000. My affidavit dated 4th of December 2024. The para 3, my lord, I have stated the application was filed for grant of 10 acres of land. My lord, what is important for your lordship to note is, my lord, he is the resident of the Javali village, Mudgere Taluk. So as per the rule, he is now required to submit the application before the concerned Taluk Tahsildar, which he has done in the year 2000. Now, kindly see, my lord, the para 4, I have said that there was an amendment to Rule 8, by virtue of which the application was required to be transferred only in the year March 2019. If that application is treated as transferred in March 2019, his seniority would be at serial number 21. And all the previous 20 applicants before him have not been allotted any lands. They are going to be allotted sites where the complainant has also been granted. Now, the application dated 23rd of May 2000, which was filed, my lord, was not supported by the income proof at all. The income proof ought to have been between 8 to 20,000. And now, by first time, by way of rejoinder, he has filed his income. That the respondents will consider, my lord. That the respondents will consider because this application was not filed with the income. Now, insofar as the second application which he has filed in the year 2022, my lord, it has been directly filed before the Deputy Commissioner, Chikmagalur. Being resident of Mudgere Taluk, my lord, he must file his application before the concerned Taluk Tahsildar, who will make an entry in their register and then transfer it. So we have fully complied with the order, my lord.
My lord,
Have you given some written synopsis?
sorry, my lord. I have filed my returns in the contempt petition, my lord.
No. Synopsis you have given.
Yes, my lord, I have filed on the 6th of,
Last time, I think we have.
6/12, I filed my,
That is the rejoinder to my fourth affidavit. It's not synopsis.
No, synopsis.
no, my lord, I've not. My lord, I would like to make a small submission. My lord. This amount of 8,000, what he is mentioning, they're mentioning, my lord, it is for agricultural land, my lord. There is in rule 4, there is a provision, it says provided that in the case of ex-serviceman, there is a separate income amount for ex-serviceman. Even prior to the amendment of 2019, my lord, the extent of income was 2 lakhs for ex-servicemen, this is not 8,000, which they have been telling it. And I am not asking for agricultural land, I'm asking for rain-fed cultivation land.
No, that matter cannot.
You have filed rejoinder. You have filed some rejoinder.
Rejoinder.
My lord, I have filed on 6/12.
6/12.
Yes, my lord.
In response to my affidavit, which I just read, my lord, the rejoinder has been filed.
I was filed on Friday at
Lord, may I make only one submission? With regard to the income aspect, it is not in dispute that for the first time that they have filed, this matter will be adjudicated by the respondent. We have said site is allotted subject to him satisfying the income. Now that he has filed, my lord, I would request.
Now you are not showing that land is not available.
my lord, that
Land is definitely
available.
not available, my lord.
My lord,
Your
land is
lordship may
available.
kindly take, my lord,
My lord,
there are
it
two
is
aspects. There are
Same
two
RTI
aspects.
application
If I may-
signed by the same person who has
Lord,
said that
may I-
the said
may I
land
make-
is available.
My lord, there are two applications, my lord. There are two applications, my lord. One of the year 2000, which we have considered, and his seniority as on 2019 would be at serial number 21. And as per the rule 8, we have allotted him a site 60/40. Now, the second application, which is filed in the year 2022 by the complainant, cannot be simply considered because his application ought to have been filed before the jurisdictional Tahsildar, whereas that application has been filed directly before the Deputy Commissioner in the year 2022, my lord. We have considered 2000, the application filed in the year 2000. His serial number on affidavit, I have stated, is at serial number 21. The previous 20 applicants are also going to be given site in the layout that we are now going to develop. None of them have received the land. He has no, my lord, may I just request your lordship to also take Rule 26 for a moment.
My lord,
Rule
putting
26
in
of the
serial number 21 is
land
direct
grant-
violation of the orders of this honorable court dated 39, my lord.
My lord, Rule 26 says grant of land discretionary. Nothing contained in these rules shall be deemed to confer on any person any right to the grant of any land. So question of complainant saying that I must be allotted this 4 acres of land, Rule 26 may be seen, my lord.
No.
So
We are in contempt.
My lord,
It will be right discretionary.
there is no question of him demanding an extent of land that he has identified by virtue of 2022 application, my lord. We have given him the site, no? Which is worth about 25 to 30 lakhs. There are 20 applicants. I have stated on oath that there are 20 other senior applicants which is pending, and post 2021 amendment, my lord.
Land is available.
Yes, my lord. It is the same person who has signed the RTA application saying the land is available.
Again, you want a particular land.
My lord, they are considering my year 2000 application, that land is not available. The next step should be whatever is available in the neighboring taluk or district has to be allotted. That step they're missing and then directly going to the step of allotting sites.
My lord, may I request your lordship to kindly permit me to read sub-rule 8 of rule 8, my lord. The second application which they have filed in the year 2022, lordship will kindly see.
My lord, we're
sub-rule
not even
8,
going to year 2022 application. We're looking at only 2000 application.
Lord, they must take a stand either we are liable to consider their 2000 application or 2022 application. Now kindly permit me to read rule 8, my lord.
You can say that you are not consistent. That much you can say.
We have considered 2000
Next
applications.
we are examining what can be done. But you are not consistent, that is very evident.
My
No,
lord,
but
it's
now-
their own applications. They are contradictory from their 2410 application to now. They ask for, they're saying that this statement is made inadvertently, saying the seniority from one taluk cannot be transferred to another taluk. They apologize for making that statement. Coming back to the latest statement, they are putting me again saying that I'm back to serial number 21. This is contradictory to their own affidavits, my
No.
lord.
Lord, may I permit, Lord, rule 8, sub-rule 8 may be seen, my lord. An ex-serviceman or a soldier shall be entitled to a land grant subject to annual income limit as specified in sub-rule 1 of rule 4. He shall apply for land grant in form 1A to the Tahsildars of the native taluk as entered in his service register. Now, my lord, the application filed in the year 2022 is in contravention of this sub-rule 8 because that application Lord, the application filed in,
Better you and be on record. 13 will take.
Lord, my only request is, my lord, my only request is, as the Deputy Commissioner of the Taluk, my lord, we have large number of applications. We have said on the affidavit, there are 571 applications. And these applications are being dealt with. Now, because of the amendment to the sub-rule 8, all the ex-servicemen are going to be accommodated in the form of sites. We have considered the application of the year 2000. We have said that they have not submitted the income, annual income. What prevented them from filing their annual income before the respondent authorities, my lord? They want to file that application here, call upon the court to adjudicate that aspect here before the court. We have given them the site in compliance with the order, my lord. We have put a rider. We have said, yes, if he satisfies the income with that, let him keep the site, my lord. We are not here to snatch away their site which belongs to the ex-serviceman.
Allotted the site.
Sorry, my lord. We have allotted a site.
That
I have
site, that
produced-
land, the survey number 201, what they mentioned is 3,000 acres of land. They have not shown any land which is available, which part of that survey number which they have allotted sites. There is no mention of anything, my lord.
My lord, we have said on
Also, it
affidavit-
doesn't even say it is in the name of the government, my lord. Like looking at the RTCs, it still does not mention anything.
My lord, in my third affidavit, I have clearly said 60 by 40 site has been given to them.
My lord,
There
where's
are
the supporting
82
document
applicants.
for? There is no supporting document. There is no layout plan, nothing.
There is an order,
sanctioned
my lord. The deputy commissioner, in fact, was present, my lord. That layout is going to be developed. Last time, the deputy commissioner was personally present to appraise the court with.
Page. Page.
My lord, my third affidavit may be taken, my lord, which was filed on 24th of October 2024. Paragraph 11 may be seen, my lord.
24th of October.
My para 11 of the affidavit. May I read it, my lord? I state that in accordance with the state government order dated 27th of October 2021, the formation of layouts extending 10 acres of land will facilitate the distribution of 60 by 40 area sites to 82 applicants out of 585 applicants in the Chikmagalur district. Next para, my lord, para 12. I state by virtue of the order and endorsement dated 23rd of October 2024, a site measuring 60 by 40 feet has been designated to the complainant by considering his application dated 23rd of May 2000. Copy of the order and endorsement both are produced at document number 2 and 3. So by virtue of this order, my lord, we have allotted the site. We have said, please satisfy the income criteria which you had filed in the year 2000. And now by way of rejoinder for the first time, they have produced the income, which I request your lordship to leave it to the authorities to consider, my lord. So the application now filed in the year 2022 does not survive for consideration on two grounds. One is we have taken the first application. His seniority is at 21. The other 20 senior members are also going to be
Madam,
allotted a
after the
site.
statement in paragraph 11 and 12, your
Lord?
main plank of grievance doesn't survive.
Yes, my lord.
So they have allotted this 16 to 40
40
feet,
site.
2,400 square feet land.
My lord, this is not the order as per the
They're
directions of.
saying on affidavit.
No, my lord, as per the directions in writ petition 26700, my lord, passed by this honorable court, the direction is first, we have to, the said land which is asked by the applicant, the same land has to be given. Next step is, if such land is not applicable, neighboring land, neighboring taluk or district, my lord, it's on their own affidavit, circular dated 24/6/2021.
We'll keep it on 13 for final court.
My lord, I would just like to make one small submission, my lord. In their affidavit dated 24/10/2024, in circular dated 24/6/21, in page 10, annexure R1, translated copy of annexure R1.
Page in the same.
It is the circular, my lord. In page 13, application shall not be disposed without, in page 13, application shall not, in pointer number 4, application shall not be disposed without attending the grievances personally. If no such land is available for disposal in the survey number requested by the applicants, necessary action should be taken to grant in other survey number of the same village or survey numbers of other village. If the land sought to be granted is not available in the district, the application shall be transferred to next district. They are going to that extent to provide land. This step has been missed by them. They're avoiding completely and they're jumping directly to allotment of site, my lord. The same DC has said the survey number is available. Now, as for the
Paragraph 11 land is not in same district. It is where this.
my lord, the rule is, even if they're considering my year 2000 application,
No,
I have
no,
asked for
please.
survey number 215.
One
If-
second, on page 4, paragraph 12, they are saying that 24 square feet land is being designated for you. Now, that is in which district? Adjoining district?
Chikmagalur district.
Chikmagalur district,
Same
it's not in my district.
Mudgere, my lord.
Now, again, that is also not in my district. That is in Chikmagalur,
Which is your district?
Mudigere Taluk. Mudigere Taluk.
Mudigere Taluk.
Yes, my,
No, this is not adjoining also.
no. This again, my lord, it's the same point they're making. If I'm going to another district, I have to be put to service serial number 21. This is in direct contempt of the orders passed by this honorable court on 39, which said that even if you, my application was transferred to another taluk,
It is that the order which you are complaining of for contempt is not that specific.
no, my lord, passed by this honorable court, my lord, on 30.
Go to the order. Otherwise, you would have,
No, my lord,
by the time this.
your lordships have passed this order on 39.
No, not by virtue of that order, my lord.
My lord,
May
on
kindly
page
take
6,
the
it says that,
Application
if
which
the-
they have filed.
my lord, your lordships have passed this order.
Look,
It says on page 6, paragraph 14,
Of dated.
39.
Lord, it
Not
may be
date.
disposed of today itself, my lord. My only request is, my lord, there'll be huge ramifications if the land is granted to them when they are not
They are
entitled.
really at a loss that why you are not granting.
Not on land, my lord. Not on land, your lordship.
My
may
lord,
kindly
land
take-
is available.
I have stated on my affidavit that there's only 12 acres of land which is available in the entire district. Chikmagalur is a eco-sensitive zone, my lord, has large areas of forest, less of revenue lands.
Which order you are?
My lord, 39/2024 passed by your lordships in paragraph 14 in page 6. Even if the application dated 35/2000 is for allotment of landing in Moodigere Taluk was not available, the allotment to grant of alternative land either in the same taluk or in the adjacent taluk should have been considered. If the complainant is ineligible, such decision was permitted under sub-rule 5, rule 8 of 69, which the authorities under state have not exercised. 15th parameter, it is not open to the deputy commissioner to contend that the application dated 3/1/23 would be considered as per seniority among the applications filed in Chikmagalur Taluk. The application dated 23/5/2000 filed for allotment in Moodigere Taluk cannot be given go by while considering seniority among applications pending allotment in Chikmagalur Taluk. As the seniority is to be maintained as per the date of application and transfer of applications is permissible from one taluk to another taluk, the application dated 23/5/2000 is to be considered as valid among the applications pending for allotment in Chikmagalur Taluk with reference to its date. This is what provided by government circular under Rule 8 of rules.
We have
Next
considered this
para
order, my
goes to say that deputy commissioner should be conversant with the circulars issued.
Lord, may I make a submission? Lord? Simple, my lord. This order has been taken into consideration and we have complied with this order. We have considered the application filed in May 2000 and we have allotted the
How many-
site. Now the application filed in the year 2022, which I have now produced, seeking for land, which they are now insisting, my lord, is filed in the year 2022, my lord. And not even in the native taluk. It is filed directly before the deputy commissioner in Chikmagalur Taluk. Am I not out to have rejected this application because ex face, my lord, such an application cannot be filed. Let us say if every ex-serviceman files an application directly to the deputy commissioner, my lord.
My lord, I'm only telling that my application 2000 is, if my application of the year 2000 is considered, that land what I've asked for is not available. What is the duty of the deputy commissioner? To find the land. I am showing that survey number 218 is available and it is also backed by the RTI applications filed by the same deputy commissioner. Also, my lord, after the orders passed by your lordships on 13/9/24, the deputy commissioner has filed this affidavit, again violating the rules, saying, again putting me back to survey serial number 21. Again, is not taking my seniority.
Lord, we may be permitted to file brief synopsis, Lord, to assist the court because there are 4 affidavits and 4 rejoinders filed, Lord, and a large number of documents.
You also give your,
Yes, I will.
see that your rejoinder is on record.
My lord?
Last rejoinder.
Last,
No.
I'll check.
13.
Sorry, ma'am.
13.
13th of this month. Lord. Grateful.
Green bench matters, still number 11. Anisha Acharya.
Narrow compass matter. My lord, in 2010, my lord, petitioner company takes up a development project, my lord, in a village called Agara near, my lord, very close to, my lord, Bangalore peripheries. 2014, my lord, a complaint comes to be filed by some, my lord, publicly spirited individuals, 3 entities, saying that though we have taken all the permissions from the environmental departmental clearance, etc., there are violations. NGT, my lord, heard the matter in 2014, passed a preliminary order, which we challenged before the Honorable Supreme Court. Supreme Court, my lord, had stayed it for some time. Thereafter, Supreme Court said that except a short portion, the matter has to be reconsidered, put it back to the NGT. NGT, my lord, passed a final order in 2016. In the NGT final order, my lord, if your lordships could kindly see, my lord, page number 337. I'm sorry, my lord, page number 157. It starts at page number 157. I only want to show your lordships 2 lines of relevant, my lord, portion on page number 230. NGT in its order, my lord, put a lot of conditions. One group of conditions was general conditions, another group of conditions was specific conditions. My lord, on page number 230, general condition 8, my lord. I was mulcted with a fine of 117 crores by the Honorable NGT. Page 230, my lord, 2230. Lord, I was mulcted with a fine of what?
Is Supreme Court order?
My lord, after the Supreme Court, my lord, page number 230 is the NGT's, my lord, second round order. My lord, on page number 230, item number 8, my lord. This 117 crores of environmental compensation fine which I had to pay, this was, my lord, the specific order. The amount of environmental compensation will be deposited prior to the issuance of amended environmental clearance. So, my lord, my environmental clearances in the meanwhile were cancelled, which was earlier granted because of the violation. So, if I had to apply again, so then, my lord, I'll have to deposit this 117 crore, my lord, the environmental compensation fee. My lord, we applied. Till date, my lord, they don't grant. On one or the other hand, and if your lordships would kindly have, my lord, page number 355, they put a lot of conditions again for us to, my lord, take once again the environmental clearance. We complied everything. On 355, my lord, one of our letter.
You paid the amount?
No, not yet, my lord. In fact, I have to pay when they are giving me the amended clearance. That is the condition, my lord, as per the general conditions. My lords, may kindly have paragraph number 9, my lord, on page number 355. Only 4 lines, my lord. My lord, on paragraph number 9, I say, as submitted above, project proponent has complied with all the conditions except those cited in the representation is being incapable of compliance, namely the green belt, distance from the territory Rajakalwe, etc., etc. My lord, we said this is not possible. You will have to do an alternative arrangement and grant me the clearance certificate.
You are saying?
Yes, my lord, we have said. And subject to which, my lord, we will pay the compensation, that 117 crores with interest, etc. My lord, we can't, my lord, we lost till the Honorable Supreme Court. Now we cannot say we will not pay. The condition is, and the second thing, my lord, we could not pay because they'll have to show us, my lord, where and to whom, in favor of whom we have to comply. My lord, when this is the situation, I am ready to pay, I have undertaken to pay, provided that as per the NGT's general conditions that I'll have to pay when they are issuing with the amended environmental clearance. I have done every other formality necessary for, my lord, obtaining amended environmental clearance. Till today, my lord, they are mulling over the matter. They don't. Now, my lords, may kindly see the impugned order, my lord, which is annexure A. What they do. My lord, annexure A, page number 36. Prior to this, there was one more NGT order, my lord, which we went on a, my lord, application. NGT once again said, please give them the environmental clearance immediately. In spite of that, they don't give. Now, my lord, what they would do on 18/5/2024, this is what they do. The second paragraph, my lord. The request has been placed before 250th SEIAA meeting held on 6th May 2024. And it is concluded that since the revocation of EC, environmental clearance, is in place, question of issuing the amended EC does not arise. My lord, this is totally against, my lord, the NGT order. Earlier, revocation itself was challenged before the NGT. NGT says, now you issue fresh, subject to all these compliances, and at the time of issuing fresh, collect 117 crores. But this is what, my lord, the committee says. The earlier revocation is in place. Question of issuing amended EC does not arise. If at all EC is required, the project proponent shall apply afresh for EC by incorporating all conditions stipulated by the Honorable NGT, including deposit. My lord, they are giving a new dimension, new meaning to the NGT.
Because it is a condition precedent.
I know that, my lord, but no, my lord, I need not to apply fresh, my lord. What happened was,
That is all.
yes, that's all, my lord. Now they say the EC which was cancelled, NGT said, no, you could not have cancelled. Please reissue them subject to certain compliances and payment. At the time when you are reissuing, collect this money. My lord, they don't do that. And I go and say, I am ready. Please take it. Issue me a new amended, my lord, clearance. They would now say, no, we have already revoked it. To take new, you will have to apply afresh. My lord, then the entire, my lord, things would start from, my lord, part here, because, my lord, environmental clearance applying fresh would require all other permissions to be taken, my lord, afresh. Right, it's as good as, my lord, this authority is rewriting, my lord, the judgment of the Honorable NGT. And twice, my lord, the Honorable NGT said, please do it.
Your Lordship, my humble submission is copies have not been served. Notice may be issued, copies may be given. We'll seek instructions. A short date may be given, Your Lordship.
You are challenging Annexure A1.
Annexure B and C, my lord. Because subsequent to this, my lord, they would issue me a show cause notice saying that why you have not done, therefore we will file criminal case against you. My lord, it's like as good as, my lord, trying to punish me for not eating without even giving me food.
But this requirement to apply afresh is only a procedural.
It is procedural, my lord. I am ready to pay. But, my lord, they'll have to issue me an amended environmental clearance certificate, my lord. Otherwise,
For that condition precedent is payment of premium.
Yes.
we will kindly, my lord, see, my lord, the NGT's order, my lord, when I have to pay, is this, my lord, general condition, which I, my lord, very humbly read out to your lordships.
8.
Page number, yes, my lord, 8. Page number 230. The amount of environmental compensation will be deposited prior to the issuance of amended environmental clearance. Now, my lord, they have to amend and issue me. Now they are saying it is over, you apply fresh. Lord, this is what totally trying to rewrite.
You first deposit with them and request them that in light of this.
We have said, but they will say, no, apply fresh. My lord, fresh application, my lord, has too many ramifications, my lord. It's as good as, my lord, trying to rebuild, my lord, something which is drowned under the sea.
CCMS you have. CCMS.
There is no escape, my lord, we have to pay. But the payment is at the time when they are issuing as an amended EC.
It's cut short here.
Page 41, you comply with page 41.
Yes, my lord, for me it's an incomplete paper. Explanation is given.
Or you are buying time to arrange for the fund.
Yes.
Mr.
May I say this, my lord? I will give, my lord, a better copy to Nilofer madam. But, my lord, our only concern is this. Can the authority rewrite the order of NGT? When the NGT, my lord, in no confused words says, issue an amended EC. Now, my lord, they want me to apply new. My lord, new application is as good as, my lord, rebuilding Atlantis.
All that you pay, you will pay the amount and we'll dispense with the applying. You pay 117.35 crores and will said that press application will not be required in light of the condition rate of the NGT.
I'm fine. I'll take it, but that serves as a purpose. Man. That serves as a purpose. I understood, my lord. I understood, my lord. I should not have been mistaken, my lord. This is another, my lord, crossroads for me to gain some more time. My lord, 117 crores we will pay, my lord. We will pay.
Notice returnable on 17th of December. Think we will compass of the controversy noticed prima facie from the submissions made by learned advocate, senior advocate, Mr. So and so for the petitioner. The petition will be listed at 2:30. Learned advocate, Mr. Mahesh Chaudhary. Learned additional government advocates. Accept notice on behalf of the state and the society, whereas learned advocate, Mr. Mahesh Chaudhary, accept notice on behalf of the state pollution control board. Let the respective respondents take instructions to clear their stand. full stop, learner advocate, senior advocate to the petitioner submits that if the requirement of applying afresh for the amended environment clearance certificate is not to be insisted upon, the petition is ready to deposit the amount of 117.35 crores, which is assessed by the NGT towards environment compensation.
Lord, may I make
So
one
great.
submission?
You have
my lord?
recorded that you are ready to.
Yes, my lord. In fact, my lord, I have said it on an affidavit, my lord. I've gone to Honorable Supreme Court and asked the matter, my lord. Now I don't have a go. I don't have a go.
My lord, may I make
Hmm?
one submission? My lord, Mr. D. Nagraj appears for respondent number 2.
In fact, my lord, if I may make this statement.
No, I.
No, not for, not on this, madam, not
the
on
same.
this.
Who is number?
They would now,
Who is number 2?
My lord, the state environmental, state level environment impact assessment authority.
Copy of the petition may also be supplied in advance to learner Mr. Nagaraj.
D. Nagraj.
D. Nagaraj, who normally appears for this to committee.
Oblige me.
in fact, my lord, if I may say this, my lord, only for 10 seconds. In fact, the pollution control board, when we say, pollution control board says pay us. Environmental committee says, no, don't pay them, pay us. My lord, that is a state controlled this thing. We don't have funds, pay us here. My lord, I am ready to comply the order. Because, my lord, I have to pay 117 crores, my lord, which is a judgment
Now you are
against.
aware what is discussed, what is transpired.
Please,
Taken.
please.
So grateful.
Please.
Oblige, my lord.
Let them not precipitate anything till then.
No, my lord, the letters
There is
will
no-
go,
there is no
email
question
will
of
go.
So grateful. I am so grateful.
It's number 12, surely.
It's a matter pertaining to my lord, deep
Covered.
conversion covered. my lord.
I,
Produced lordship's order at annexure F, page number 33,
next ref.
page number 33.
Number 13,
Lord,
TV not.
this is against SOCO's notice only.
Yes, ma'am.
Only against SOCO's notice.
Not against Local. What happened is here, the act provides for personal hearing under section 44(4), my lord.
Under
Any
sec-
penalty,
Under section.
44(4), rule 44(4) of the
They will
KMC
give,
rules.
it is expressly provided, you will give.
Yes, my lord. Yes, it is provided.
So
And my
then
lord,
this is only at the notice stage, nothing is fructified.
Yes.
and my
lord,
lord,
and that
then
was
my lord,
16, 10, 20.
what happened is, the rules provides for the method of transportation.
How
and-
do you apprehend that they will not provide you the personal aid at this stage?
No, my lord, they have already quantified the penalty.
Then we'll say that person is lying. Very
Kindly
clear.
look at the order. My lord, section rule 44(4) is very clear. May I read you? The relevant section, page is, my lord, page number 15 in the order. My lord, may I request your lordship to the rules? My lord, rules 44 proviso.
What is quantified by them?
My lord? Yes,
You said something is quantified.
yes, my lord. Kindly look at, my lord, page number 15. Page number 15, my lord. Page number 15, 15. My lord, it is only on the basis of, my lord, kindly look at.
It is some amount is quantified.
My lord, this is
No
the.
amount is
No, kindly look at-
quantified, my
my
lord.
lord, kindly
Please
look at-
see
no, no.
the second
I'll
sentence.
clarify, I'll clarify. Kindly look at the last two lines. You are hereby called upon to pay the penalty equal to 5 times of the royalty.
That will be assessed after you are heard.
Yes.
No, my lord, 44, kindly look at the order, my lord.
Like-
44(4), my lord, KMC rules with regard to the quantified amount of minerals transported, that is 35,416. Well, it comes about, my lord, 35 lakhs. That is quantified.
My lord, the next, my lord, the entire sentence has to be read, my lord.
My lord, if they are saying it is not quantified, my lord.
Notice has been
it is
issued.
to my benefit, to my benefit.
Failing
Rule
which
says-
action will be
Rule
taken in
45(4)
accordance with law.
45(4) proviso says, provided that no such order of determination of penalty without giving a lessee license and opportunity of being heard. Lord, I have repaired the show-cause notice. My show-cause notice was not considered at all. Lord, the basis for the order, kindly look at, my lord. Rules provide for the method of, my lord, giving mineral dispatch permit. provisional, 44-4.
So that you are bound to give hearing.
My lord may dispose it of if they are satisfied that,
My lord,
my lord, the sentence may be seen.
ಅಲ್ಲ ಅಲ್ಲ, penalty. ನಾನು ಕಟ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೀನಿ, ನೀವು opportunity ಕೊಡಿ ಅಷ್ಟೇ. And in similar circumstances, earlier also, my lord,
No,
what was
my
made.
lord, may I make
It is
one
on-
submission and I'll leave it to my lord, my lord, one submission. My lord may take, my lord, the second sentence in that notice. My lord, notice has been issued in terms of reference number 5, asking you to respond within 15 days as to why action should not be taken under Rule 43 and 44 of the KMMC Rules 1995, and your response to the notice is not acceptable. You are hereby called upon to pay the penalty 5 times of
Yes.
royalty with regard to so-and-so, transported without payment, without permit, failing which action will be taken in accordance with law.
So I had to pay.
Includes the 44-4
Yes,
proviso.
yes, my lord, that.
So it
in fact-
includes, notice
Yes.
very much includes 44-4 proviso.
Whatever, no, it is, when you cut, my lord,
Notice mentions that under Rule 44-4 and 45-4, therefore it includes the hearing part.
my lord, now,
Jurisdiction of this court under Article 226 of the Constitution is invoked, seeking to call in question notice dated 16/10/24, issued by the senior geologist, Mines and Geology Department, Mangaluru. The notice paragraph contemplates to require the petitioner to show cause as to why the action should not be taken under Rule 43 and Rule 44 of the Karnataka Minor Mineral Concession Rules 1994. The petitioner is called upon to pay the penalty equal to 5 times of royalty under Rule 44-4 into bracket 4 and 44 into bracket 5 of the aforesaid rules. The penalty is sought to be levied with regard to 35416.3158 metric ton of raw materials stated to have been transported without permit. This notice is issued, impugned notice is issued first with reference to the notice earlier issued on 3/7/24. It is stated in the notice, instant notice, that the technical officer inspected the premise of the petitioner crusher unit, the petitioner's crusher, granite crusher unit.
building stone.
Petitioner's building stone unit, which is operated on the land survey number 1/1A1, capital A, 1A1 of Andavra village, Mangalore Taluka. Which has the capacity, annual capacity of 30 loads/day in metric ton. Notice indicates that following was detected in the section, so Roman 1 and Roman 2, which is regular 1 and 2, page 15, to be in continuous. It is further stated that the petition has consumed 249297, 249297 units of electricity, and therefore might have crushed proportionate raw material as indicated between the period mentioned. It it is further stated that accordingly, the material is transport to the extent of 35416.3158 metric ton without mineral dispatch permit. The notice looking explanation paragraph is based on the aforesaid actual aspects. Two aspects are evident. First, petitioner will have right to raise all his objections and defense in response to the notice. Petition under Article 220 premature in that context, since the petitioner is yet to show cause and the authority is yet to proceed. Determine. Secondly, it is certainly there is no gainsay that though the penalty equal to 5 times of the royalty is demanded under rules 44.4 and 44.5 of the rules, so there is no assessment undertaken. Full stop. The assessment of the amount to be paid, which may be paid, which may be required, which may be required to wait, if or assessed, will have to be done after formal adjudication and assessment, which is to be done only after considering the reply of the petition. Therefore, both the aspects are still not exhausted by the petitioner and the authorities respectively. Full stop. Learned advocate, Mr. So-and-so petition paragraph would submit that the petition is not given personal hearing. Full stop. This submission is without any merit at this stage, inasmuch as proviso to subsection 4 of section 844 clearly says that any order of determination of the penalty shall not be made without giving the lessee or licensee opportunity of being heard. Full stop. Learned additional government advocates, Srimati Neelofar Akbar, certified in submitting that there is nothing to indicate that this authority will not abide by the mandate of the provision of giving personal hearing to the petitioner. In the aforesaid view, the petitioner is at liberty to file reply to the notice and the full notice, which shall be done within 10 days.
2 weeks.
Yes, in 2 weeks. Full stop. Thereafter, the
No precipitative act.
competent authority shall act in accordance with law and proceed to determine the penalty, if any, after considering the reply of the petitioner, to pass necessary orders to be communicated to the petitioner within a period of further 6 weeks.
Yes. And until then, well, on the basis of this, no precipitative act.
The petition is disposed of,
Yes.
without expressing any opinion on the merits.
Apply.
Number 14, sir, writ appeal matter with Keshav Bhatt.
Hearing. Notice returnable. Delay.
Delay.
Murder. 13th February.
Notice 13. Number 15, Shekhar L, 15.
Yeah, 15. What is the delay in filing the petition? Nobody is there. Delay in latches of voting. Nobody is there.
Shaker L.
Kick back.
Syllabus 16 says.
Notice.
By state.
Notice it. Notice delay is there.
Notes, the four petitioners, they're on K-8 notes. They are on
Prepare for
K-8.
it. Any other party to be served?
Notes, UGC is there, who was a correspondent.
Notice returnable on 7th February.
Notes, we may be permitted to take out notice on the UGC council also.
Or learned educated so and so and so. Express notice on behalf of
1 to 4.
1 to 4
Four.
respondents.
will be open for council for the petition to serve the copy of the appeal to the learned counsel who normally appears for respondent University Grants Commission,
Please, HR Shauri,
in addition to normal order.
normal notice. Notes, there is some urgency. It is about 10,600 milots guest lecturers. Appointment milots has been stayed on account milots of the single judges.
Earlier, let us,
No, no, my lord, it has not been stayed, my lord. Court, single
been
judge has
quashed.
only said,
10th January,
yes, my lord, much of.
Notes,
not before that.
next week.
No,
Sure.
not.
December 17, HV Devraj.
Same notice written on January, February, February 19.
18 to- Cell number 18. Okay,
The applicant in this matter, my lord.
Rupashri.
My lord's workman has been dismissed from service for serious acts of misconduct of go slow. He raises a dispute before the labor court, and when the matter is pending, he asks for 50% of the last drawn wages to be paid as interim relief, my lords. And the question of law is, he has not
Okay,
proved a prima
What is the
facie
sig-
case.
What is the significance of 16/1 to 15 date? 16/1/15. What is the significance of that date? Because the learner single is granted 50% from that date.
That was the date when he filed an application seeking interim relief.
What is wrong in this?
My lord, he has admitted in the cross-examination before the labor court that he is financially sound, he is cultivating, he has lands, agricultural lands. My lords, and he also says his wife is working as a nurse. When can an interim relief be granted, my lords? When he is absolutely not having a single rupee to maintain himself, then interim relief can be granted, my lords. In his cross-examination, my lords, he has clearly stated, my lords, that he I think it's at page number 102, my lords. This was brought to the notice of the single judge, my lords, but 102, my lords. It's a fourth parameter.
Understood.
I'm sorry, my lord, sir, little late in reaching.
This order came to be, interim order came to be passed by the tribunal
Lords, may I make my submission, my lords?
provision. Order was passed under which provision?
My lord,
10-4.
Lord, this order, under section 10(1), reference was made. Now, my lords, nobody disputes that the labor court has the right to grant interim relief when the case is going on. The main issue is only on the ground that a workman is not employed, can you give interim relief? Or should you look to the merits of the case also? Supposing there is a case where a workman has misbehaved with a lady employee and I have to dismiss without inquiry. When that person comes, then the labor court say he is starving, therefore I'll give him interim relief without going into the prima facie aspect. That is precisely what the Supreme Court has said and what our High Court has said in number of cases. I have produced two of them, one inclusive of Supreme Court, where the court says, yes, you have a right to grant interim relief, but you must say what is the misconduct. The misconduct here is go slow. Machinery gets spoiled. Entire production gets affected. Supreme Court has said it is a picturesque description of ruining the industry. And therefore, in a case of go slow, when I have produced sufficient evidence, should the labor court not go into that question, whether there was go slow prima facie? Neither the labor court nor the learned single judge makes even a reference to the merit of the misconduct. I can understand if the misconduct is unauthorized absence.
Where is the judgment? Which judgment you are relying?
What?
Which judgment you are relying on?
I filed along with the list of authorities the judgments before this honorable court. Kindly see, my lord, page
Is filing?
2 in my first judgment. Ink page 2. There's a small booklet which contains the cases. Filed on in the market exceeding.
Their judgments are not here, but then we issue notice letters. Notice returnable on 5th of 10th of January.
Much obliged.
You just put your judgments in.
I'll find out time. Sorry for the.
Or learned senior document, so and so, assisted by learned advocate, so and so, notice written. Yes.
Till number 19, the MC Basaraj.
The appellant was a driver. On certain charges, disciplinary proceedings have been initiated. The inquiry officer held that charges were partly proved. Then even the disciplinary authority also held that the charges level.
You are dismissed today.
Yes, my lord.
Appeal is admitted to be listed for final hearing in the beginning from 22nd April.
Lord, by virtue of interim order passed by the learned single judge.
You are dismissed today, out of service. Nothing more can be granted.
Thought was stay of.
How can it be granted? It will amount to allowing the petition, appeal. Yes, we'll hear finally.
Commercial appeals, still number 20, the Pradeep Nayak.
This is an appeal from a commercial suit for infringement of a trademark. My ex parte order was granted. I have been using a trademark since 1998. in relation to a hospital.
Shut down this for final hearing after,
It's the,
immediately on reopening.
My lord, may I
This-
just make one
This
submission?
will take time then.
Indeed,
will not take more than half an hour on each side.
My lord, trial has progressed substantially. It is, my lord, the case management schedule, my lord, it is supposed to end on 13th of January. Because of some delay, my lord, on the part of the plaintiff, it is now, my lord, fixed for their chief examination on the 10th of January. In all likelihood, my lord, within a short date after that, the evidence will complete.
My lord,
So, my lord, there
these
is really,
commercial suits still take more than a year from the date.
I'm sorry, my lord,
In
that
the
is
meanwhile, I am
entirely
entitled,
attributable to them.
I am entitled to interim protection.
That aspect we'll put up on 10th of January.
My lord, on 10th, my lord, we have before the trial court, maybe on 11th or 12th, my lord.
Or any date before the 10th, my lord.
Because no, my lord, I want to place the cross-examination also on record. My lord.
Then 10th, after 10th, it will be
Could it be prior, my lords, because could it be on the 9th?
15th January.
Please, my lord.
Lords, would your lordship?
I'll complete the cross-examination
See the
before.
13th, whenever you.
As a date
13th
prior,
is fine, my lord. My learned friend wants an earlier date.
my lord, a date prior to the 10th, if it could be, my lord.
Not at all, my lord, because I want,
Because
I want.
what
to
they are
cross-examine their
attempting to do is to say that this is infructuous.
He wants prior to 10th.
Prior to
My lord,
10th.
because on the 10th, his witness is coming for cross-examination.
That should have no
My lord,
bearing
that
on this at
deposition, my
all.
lord, will play a major.
How can the
bearing on, my lord,
cross-examination
the-
have any bearing on my interim?
Exact-
The Honorable
To
Supreme,
demonstrate that.
If the appeals are kept on 8th and the proceedings are to come up before the trial court on 10th, very good ground for him to ask for adjournment.
Please, my lord.
the trial
My lord,
court
let it
should
be
not
added
come.
on the 12th, my lord. On the 12th, I.
My learned friend will allow me to speak 2 words. The trial court should not come in the way of this honorable court considering my interim relief.
No,
The
no.
Honorable Supreme Court has said the minute I have a registered trademark, I should be entitled to protection. Simply because trial is proceeding is
Lord,
no
kindly-
reason for him to
Time being
come in the way of
let
this
us-
hearing.
I'll leave it to my lord.
8th,
My lords,
8th of January.
deeply obliged.
21,
We'll try for advancing the other matter.
21 is the same.
Both are. What is the difference? Same.
Same.
My lord, one is a passing off application.
2
one is
IAs were
one is
filed,
an
both were.
infringement. Grateful.
so number 22. To Bhuvanendra Raju.
Defendant's appeal before my lord's, my lord. Matter relates to purchase order under which they claim that I have not supplied the goods. My lord, the plaintiff was a workman, was a contractor for one Best Gold in India Limited, with whom I had transactions from 2017 onwards. This Best Golden was due in a sum of rupees 1 crore and odd as on the date of this purchase order.
Money decree.
Pardon, my lord?
Money decree.
Yes, money decrement.
A money decrement. My lord, there are one other aspect is there, my lord. Though the principal sum is now 64 lakhs, I am prepared to deposit the principal sum, my lord. If my lord reads the decree is on 97 lakhs with interest plus interest. And the purchase order, I'll place the purchase order. The purchase order does not stipulate any payment of interest. The court has granted 24% interest, my lord.
I'll make some.
Our produce ಮಾಡಿದ್ದಾರೆ 46 page.
Page 46 of the.
Done.
Sometime I'm prepared to deposit the entire principal amount within some time frame, my lord. Though strictly speaking, I had to recover the amount from his principal after about a year and a half after filing check bounce cases and etc. All those documents I have placed on record. The court comes to the conclusion that they are independent transactions and that I have been unable to demonstrate that he indeed is the agent of the principal who was due money to me.
Lord,
Kindly see the.
I have produced, my lord, entire documents along with, my lord, admission which they have given. I'll place your lordship. This is, my lord. Can I make submission?
My lord.
Set down for hearing next.
1 second, my lord, because, my lord, that is they have admitted, this is, my lord, that I have placed, my lord, purchase order. He is, my lord, that the dealer, we have paid 74 crores and 74 lakhs to them by placing purchase order. From 2020, my lord, till date, they are holding. And they have admitted before the trial court that whatever documents which they have taken contents in the written statement document produced, is nothing to do with, my lord, the claim of the petitioner. Apart from that, they have admitted receipt of those amount. And, my lord, everything admitted. For a moment, my lord, I'll draw your lordship's attention, my statement of objection in page 83. Cross-examination, they have stated exhibit D2 to D39, which they have produced, is not belonging to the, not pertaining to the claim of the plaintiff. Apart from that, they are illegally holding 74 lakhs, claiming that someone else has to pay them. That is the case, and they have admitted everything. Under those circumstances, my lord, last date of hearing I have submitted. If your lordship see his admission, my lord, everything will be, this will be closed. Therefore, my lord, if your lordship see admission of the DW1, which cross-examination, he admitted everything.
Till after vacation, we sit down.
Let them not precipitate execution. Last time they have undertaken not to precipitate, let it continue. My lord.
Execution, my lord, that we have filed, but not yet we have taken the steps.
Let that
Simply-
undertaking continue. my lord.
Simply, we are adjourning to 17th January.
Please.
Please. Much.
Still number 23. Mr. Pradeep Nayak.
This matter pertains to the felling of trees. My lord, your lordships had granted permission to an extent on 27th September. Can I request your lordship to look at the order dated 27th September? My lord? Your lordship had granted partial permission. Subsequently, your lordship directed to inspect and give a further report. That has been done and placed before your lordships, my lords. As for that report, my lord, they are given certain suggestions. I think in view of the subsequent, my lord, in compliance with the report being in compliance with your lordship judgment, my lord.
The last filing.
IA number 7, my lord. It was filed court of. IA number 7, my lord. Dated 21st November.
So that is your report.
Please, my lord. Earlier, my learned friend for the petitioner, my lord, they had pointed out certain errors in the earlier report which was filed before your lordships. Can I request your lordship to kindly go through the order dated 27th September, my lord, for a moment, 27th September.
Yes, it is there.
Para 6, my lord. The tree committee shall revisit each of the above trees mentioned in serial number 110 to 507, as well as serial number 605 to 646 in the official memo dated 29th May, to re-examine the feasibility and the permissibility of felling the said trees. After undertaking the inspection, the examination, the separate order shall be passed with reasoned recommendation as may be thought fit by the advisory committee. The exercise shall be completed within 3 weeks, looking into the total extent of area. Fresh order shall be passed by the tree officer based on the recommendation of the committee. Rest of the trees except the above are permitted to be removed by the applicant if found to be falling within the project upon compliance of the conditions which I have already mentioned. Similar order may be passed, my lord, at Roman 5 in view of this serial number 110 to 507, my lord.
Correct.
That's all we are requesting.
So you are already permitted to cut.
Please, my lord, except for this.
Your lordships had permitted some of the trees. For the remaining 440, they have redone the process. We have not filed any objections to this match. They seem to have been in compliance with your lordship's directions.
So therefore,
So we are not objecting to
But
this
the
IA.
petition will remain pending.
Yes, ma'am.
Permission to fell the trees may be.
The IA number 7 is being, IA number 7 has been filed by them for this permission. That may kindly be allowed. The petition, there are still a large number of issues that need to be resolved. In fact,
So my request to your lordships is to allow IA number 7 in view of the compliance of your lordship's order.
Yeah, right.
How many it is? 440.
440.
So they are inspected now.
Please, my lord, inspected and report also has been filed, my lord, in terms of your lordship's direction. In fact, my lord, similar order in terms of 6-5, which is already passed, may be permitted, my lord, in so far as which is order dated, your lordship, 27th September, my lord. Same order insofar as the at serial number 1 may be passed. 27th September at para 6. The restriction is imposed in paragraph 5. Rest of the trees above are permitted. So therefore, my lord, now your lordships may kindly grant permission of at serial number 1. That's all. Can I give the copy of the order, my lord?
It is there.
It is there.
Where is the memo of petition? Main petition. In the proceedings of main petition, which is a public interest litigation, in which the petitioner Bangalore Environment Trust prayed for directions against the authorities to discharge their duties and functions under the Karnataka Prevention of Trees Act 1976 and Karnataka Prevention of Trees Rules 1977, as also to adhere to the guidelines set out by the judgment of the Bombay High Court with regard to the felling of trees, an interim application number 5 of 24 came to be filed by the applicant who was original respondent relevant, praying to vacate the order dated 12/6/24, which was passed in the writ proceedings, whereby the respondent Brahat Bangalore Mahanagarpalika was prohibited from felling the trees. In the said paragraph, application number interim evidence 5 of 24, the applicant Rail Infrastructure Development Company in Karnataka Limited Right, for permission to fell the trees. For the reason stated in the application. On 27/9/24, in the said interim application proceedings, the court passed order, extracting the relevant part. So from paragraph 3.4 onwards till paragraph 7. While the aforesaid interim application was disposed of in the aforesaid terms, and upon imposition of conditions and issuing directions on the applicant who wanted permission to cut the trees, today when the proceedings of the petition come up, they accompany interim application number 7/24, which is filed by the said applicant Rail Infrastructure Development Company, case respondent number 11. What is right in this interim application is as under. Then for the reason stated. Within the jurisdiction of Bangalore Metro EMRD category. In the accompanying affidavit, it is stated inter-alia by the applicant as origins from 1. Rail Infrastructure Development Company, Karnataka Limited. That pursuant to the directions and observations of the court in order dated 27/9/24, aforequoted, what is TEC, Technical Evaluation Committee? What is TEC?
Tree Expert Committee.
Tree Expert Committee, into TEC, inspected each and every tree which were so proposed to be cut, was without subjected to any survey. Full stop. The survey was thereafter undertaken in respect of each such of trees, totaling 440 trees. And the report relating to each was prepared. About the compliance with the directions, it is stated in the affidavit by the general manager of the Rail Infrastructure Company as under, as found in paragraph 5. The indicated person in compliance of the direction. Court in location was visited in 22/10/24. Thus, thus it is stated that the spot inspection and the field inspection was undertaken in respect of each of the 440 trees. And the same was surveyed. Purpose of feasibility and advisability of cutting those trees. It is further stated that the physical verification of trees was undertaken by the TEC. And it was found that there was no possibility of saving those trees. Therefore, the removal of trees, remove all the 440 trees was recommended, is recommended. The TEC has assigned reason for removal of each tree individually. And the report is produced along with the affidavit. And we get figuring at R2.
Page 80.
Page
801.
The perusal of the state report will next up R2 page 80 bracket over indicates that it is a detailed report where the physical survey of each of the tree was undertaken and was physically assessed for the purpose of its removal. It is further stated that the company has undertaken compensatory aforestation work to the Brihad Bangalore Mahanagarpalika, planting 10 healthy saplings for every tree that is felled or to be translocated. It is further stated that the work orders have been already issued in this regard for planting 7,880 saplings within the BBMP limits, which is in compliance of the directions of the original memorandum dated 29/5/24 and in pursuance to conditions imposed by the court in that regard. Full stop. The fact stated paragraph in the affidavit regarding compliance of the observations and directions in previous order dated 27/9/24 passed by the court is satisfactory and deserves to be accepted. Also, learned advocate for the respondent original petition, Mr. So and so and so, was also not in position to dispute the factum that each of the 440 trees now proposed to be cut has been inspected, surveyed, and assessment is done in that regard for the purpose. Assessment is done for their removal. Advocate, recommending the removal, and further the removal, recommending the removal, and further that the compensatory plantations are also undertaken. It is completed or started, compensated?
They have not, they
It
would
just
not,
started, Manoj.
They started.
Subject to compliance of that, we'll do, Manoj. The OM
they
says,
do it subsequently. They have to undertake to do it, Manoj.
once your lordship grant permission, Manoj, then I can start everything, unless your lordship grant permission. Your lordship is in compliance of the OM, Manoj, because the OM gives us how I have to go about. Before I start, I require your lordship's permission to do it.
While disposing of the present IA number 7 of 24, granting the prayer made therein, it is however directed that the applicant Rail Infrastructure Development Company, Karnataka Limited, shall place in record a complete detail of the compensatory plantation which may be undertaken and completed along with simultaneously with removal of 440 trees. Such reports shall be filed in the proceedings of the main writ petition number 1784580.
Please,
Within two months.
it will take some time, Manoj, more than.
soon after the.
Once the
Soon
sleep-
after the removal of the trees is over, soon after the work of removal of the trees is over, and that the compensatory plantation is. done.
Please, we'll do that.
Your lordship may give some time period because on this point I have filed
3 months.
3 months.
3 months. This
3
shall
months
be
is
done.
reasonable.
This, the above shall be done,
My lord, your lordship, may 3 months, your lordship, but we may require some more time, my lord.
preferably within 3 months.
Please,
Full stop.
let them file an application for extension if they are not.
Preserve
able
that labor.
The reason I mentioned, I'll bring
If
it.
it is not possible to be done within 3 months, the applicant rail infrastructure development is permitted to file
Please.
application for extension of time to be considered in accordance with.
Please, my lord, that's.
Put up on
Plus,
today is.
one more submission, Manoj.
March will, April will put up.
Plus one more submission,
3rd April.
Please.
one small submission. It's in similar circumstances, OMs have been granted for respondents 5 and 7. They were directed to produce quarterly reports and several compliances. On 19th of October, I have filed one memo that BMRCL is not in compliance of those
What
directions.
is to be complied with?
The quarterly reports, all the trees that they translocate and in
Not
this,
certain-
not this respondent, 5 and 7. They are supposed to file every quarter. They have not filed for 1 year now. So whether those trees are surviving, whether the compensatory plantation has been completed, they have not reported.
Done it,
beyond
friend,
report.
man.
The last quarterly report is for December 2023. On 19th October, I filed, and I have been repeatedly writing to them saying, please let us know what the status is. They do not respond to us.
Head of separate order in writ petition. Full stop. Learned advocate to so and so the petition submitted. That the respondent BBM.
BMRCL, Manoj,
BMRC.
and KRDCL, respondent 7. I have filed 2 memos. Both of them.
There's no direction to give.
KRDCL, I have filed 23rd November, detail of every non-compliance of theirs. 23rd November, there's a series of non-compliances.
Sorry,
I filed a memo. Let them file their reply and report to the Honorable Court
so-
why they're not complying.
In so.
Various orders are passed in the proceedings and the directions are issued to the respondents. More particularly, respondent 7 and
Respondents 5 and 7, man.
5 and 7. Yes, full stop. The said
There's no
respondent
such
says that
direction to us.
all other respondents are required to.
There's no direction to us.
Comprehensive affidavit,
Lord,
public response, dealing with the aspects which are
in,
required to be observed by the court in its various orders.
I have one submission to make. Lord.
This shall be done with, before the next date of the year.
Yes,
Please.
we have filed an application, Lord, for respond number 7, which is IA number 3 of 23. While granting one permission, Lord, we were directed to carry out certain aforestation. Now, under the government order, we have to make payment of that amount of money to the forest department because the forest department is regarded as a nodal agency to carry out the entire afforestation, which we have done now. We've paid the entire amount of money immediately, my lord. Now, we are not getting any information from the forest department, my lord, as to how much has been completed. Therefore, my lord, we made a request to your lordships not to direct the government now to give us that information. Because otherwise, my learned friend is after us saying you're not providing the information. Beg your pardon, my lord?
You seek information by writing to them.
Lord, we write to them. We've written any number of letters to the department. I'll give it
I'll
to my
get the
learned friend.
information, my lord.
Purpose of,
Yeah.
for
They
the
don't give
purpose
us
of
any-
compliance purpose, any
They are asking for
information
money.
which is required to be provided by the governmental authorities to the applicants or parties concerned shall be provided once the necessary application in this regard
Yes.
requiring the specific information are given by the party concerned to the competent.
Yes.
Obliged, my lord.
Deeply obliged.
It's okay. That's one answer.
Which is not for us.
Grateful.
Madam. Date for difference. Date is 3rd April.
Grateful.
So IA is this first. IA 7 is this.
Still number 24.
For the petitioner, my lord.
PV Nidhi Sri.
my lords will recall, this is that matter where the road in Badegi city has been completely,
Already late.
my lord?
Road is already late.
No, my lord, road is not late. In fact, they have filed a report. The municipal council has filed a report on 27/9/2024, where they say the respondent 4, PWD, has to lay the roads. If I could take my lords to the report itself. 27/9/2024, report filed by the respondent number 2, my lord.
My lord, respondent number 2 has now filed a memo for retirement. There's nobody, respondent number 2, there's nobody to represent the respondents, my lord.
Who is number 2?
Mr. MV, my lord, this is the Chief Officer, Badegi Town Municipal
yes,
Council.
correct.
He's filed a memo for retirement.
Who retired?
Yes.
Why?
Nahi.
The council file.
Yes,
Yes, my lord, only the council.
It stated that the council for even 2. Municipal council has filed a memo for retirement. In that there should be notice to the respondent to afresh. No press notice number 2.
Could it be taken up on Wednesday or Thursday, my lord?
Respondent about the proposed, about the memo filed as above, and in order to enable respondent to make alternative arrangement.
My lord, may I make one submission, my lord? My lord, we are making efforts, my lord, to see that the roads are laid, my lord, and the roads are widened. But what has happened is, my lord, the people from whom we are trying to acquire the lands, my lord, they have challenged that same, and that writ petition is pending before the Dharwad bench.
There is no stay whatsoever with regard to that, my lord, merely because there is some proceedings, acquisition proceedings pending.
If
Does
my
not
lord
mean
could get
people
that,
there.
my lord, if that also could be considered by my lords, it will be easier for us, my lord, to see that. My lord, the writ petition which is pending in Dharwad, if my lord could, my lord.
My lord, they're simply expanding the scope. All that we are asking is please lay down roads, cover the gutters, the drains, so our children don't die of dengue.
You show the development there, we take into account, but not pass anyone.
Right.
Notice will be returnable on 6th, 7th February.
My lord, could it be an earlier date, my lord, anytime, if this. The matter has been pending for a while, my lord, and the situation is quite bad.
Prayer is very simple, my lord.
21st January.
Obligement.
Very well, ma'am.
This ready
But
notice
in the
matter.
meanwhile, could I request, my lord, one request, my lord? I've already filed an application for appointment of a commissioner. If maybe the District Legal Services Authority, some official, can be asked to inspect and have a report ready and file it before this court.
Let the parties here, all the parties.
My lord, there'll be no prejudice caused to the municipal council, my lord. There's already an IA pending because there will be a delay of.
On that day will come.
Very well.
Ready notice matters. Number 25.
And for the petitioners in this case, my lords, request for an adjournment, my lords. We have to file the rejoinder on this.
About what?
No, submission is being made. If you ask me, I get distracted.
What is the interim relief operator? Any interim relief operator?
No, my lord. My lord,
Doesn't appear to. If there is an interim order operating today, there is some continue. What is the interim? Not. What can be the relief here? No relief. Even if it is there, we will vacate it. Why you are seeking time? Some orderlies have to be appointed by the police department. How we are concerned? How we are concerned all with all?
My
Are we
lord, I
running
have no
police?
instruction, my lords.
Are we running the police department?
We have to file the rejoinder, my lords.
No rejoinder. Yes, we find out what is-
My lord, we have filed a statement of objections, my lord. It's on 11 December 2021. My lord my lord may please take paragraph 3, 4, 7 and 8.
29/11? No.
My lord is dated 29/11/2021. My lord may please take paragraphs 3, 4, 7 and 8.
3, 4, 4. Yes, madam, we are not inclined. Continue. with it.
My lords, place for short accommodation. Senior is unwell, my lords.
To be listed at 17th October.
Obliged, my lord.
Please.
It's number 26. Mr. Nayak.
Serial number 26 is not available. A short accommodation maybe,
February.
please.
My lord, I am for the respondent number 1 in 26.1, my lord.
At the request of learned counsel for the respondent, coalition control law, and the 8th of February.
Grateful, Your Lordship.
Number 27.
Same request for serial number 27, Your Lordship.
27, I appear for the petitioners, my lord. This matter,
My lords, I have filed an impleading application, my lords. Let them file their objection, my lords, whatever they have to
his
say.
copy has not been served.
I've
to
served a
me.
copy on email, my lords.
Serve the copy.
My lord, this
I've served a
matter,
physical copy.
for a moment, please, my lord, may put the facts before your lordship. This matter is pertaining to environmental compensation.
My lord,
Which has
171 lakhs.
1 crore 71 lakhs has been imposed on me. I am a builder, please, my lord. 10 years ago itself, I've completed the apartment. OC has been issued. I've spent 36 lakhs putting that sewage treatment plant by some person, company who has been authorized by pollution board themselves. Thereafter, for the period of 2019 to 20,
Interim order is operating.
no, my lord, this is the first time it is, second time it has been coming, please.
My lords, the impleading applicants, my lords, are the residents of the apartment, my lords, that was put up. They put up, my lords, a faulty STP, my lords, where the residents are still suffering today.
My lord, I will address on that. They are either they want to pay the environmental compensation or they want to collect it. They have no locus before in this particular petition, please, my lord. To intervene in this matter.
Leading. What do you want?
My lord, I am playing for interim relief. I have just come out of insolvency. And
IA.
my lord, there's no separate IAS.
IA for impleading was filed on Saturday, my lords. We had Saturday, my lords. The copy was served on email to the petitioners, my lords, under respondent number 1.
It is the number.
IA number 2 of 24, my lords. And an acknowledgement also has been annexed, my lords.
My lord, association is okay. They have issued a letter saying that there is no problem with STP. This one particular person is interfering and forcing pollution board to file this compensation and try to recover, please. The malicious prosecution, please.
Kindly request page 58 of my impleading application, my lords. There's a judicial order, my lords, where I have sought for impleadment in a criminal petition. That has also been allowed, my lords. Page 58.
My lord, that is pertaining to, he was a complainant therein. This is a different writ petition for setting aside the environmental
So
compensation.
impleading applicants are 3 to 9,
Yes, my lords, 3 to 9.
who are the owners of the apartment.
Yes, my lords.
Residents
of the association, apartment, my lords.
So they may be permitted to join.
Yes, my lords.
I'll file my objection, please.
What of?
I kindly take page number 143 of my petition.
File it. Learned advocate, Mr. Sohan, wants to file objections to IA number 2, which may be filed before the next day, put up on 10th February.
My lord, I'm praying for an interim relief in this.
It can't be granted.
No, the reason, please, my lord, may I submit for us?
Because the impugned order is of the year 2020, my lords, not of 2023 or 2024. Or
Till
2020.
date, it has been functioning correctly and there is no problem with STP. Only for the period of 2019-20, for a period of 1 year. Only for that particular period, he is asking for this thing. Where is it? Letter.
No interim leave can be granted.
I have asked, in fact, pollution board, if I have any problem in STP, you show me, I'll rectify. They don't want to do. They say that you are unscientific. If they know the science, let them share the science, please, my lord.
Let it be heard. Let the main matter heard.
In the interim, let them not precipitate on that letter, please. My company will close down. Employees will suffer out of that, please. My
All are apprehended.
lord. A date may be fixed, please. My lord.
10th February.
Gift notes.
Number 28.
Lordships, WP 2023 of 2024 may be first taken, Your Lordships. There are two writ petitions, Your Lordships. Writ petition 2023 of 2024 may be kindly taken, Your Lordships.
Who have you?
My lord, I have here.
File an application.
It can be taken after this,
Lordships,
after vacation can be taken. 8 January.
much obliged.
Number 29. Ganpati Bhatt.
For petitioner, my lord. I am seeking, my lord, withdraw the writ petition with liberty to file in case necessary, because, my lord, they are considering my prayer subject to withdrawal of this writ petition. Therefore, my lord.
But honored advocate Mr. Bhatt Ganpati files memo dated 12/24 in which stated
Thank you.
petitioner may be permitted to withdraw the writ petition that is not pressed. And if necessary, the petitioner may be given liberty to file. First, dismissed as withdrawn, you have the petition is dismissed as withdrawn, you have the memo which is taken on record paragraph. Liberty is reserved, file a petition upon the rise of press for the.
Please, much.
Number 30.
In this case, my lord, I am appearing for petitioner. The query list has been granted, my lord. Your lordship directed them to produce, my lord, file of the pending before the, my lord, fourth respondent. Here, my lord, that I have made an application for grant of query list. And thereafterwards, my lord, the considering all aspect, my lord, the query list has been granted by issuing notification at ink page number 25 annexure B, my lord. Notification granted under section 20, rule 27 of KMMRC rules.
My
By
lord,
grant,
my lord, could I seek for a short accommodation? I haven't received the file, my lord, to inform my lord with regard to the, whether the order has been served on them or not.
that is what direction has been was. Date may be fixed, my lord, first week of January, my lord.
16 January.
Please.
Obligement.
But
Number 31. Mr. Saravanas.
Appear for petitioner. Lords, could this matter be taken in next week, my lords?
After vacation. 13th January. Interim order shall continue to operate.
Number 32. Mr. Kalyan R.
For petitioner, madam. This PLR pertaining to encroachment of storm drain water, madam.
Encroachment over
Encroachment
the
of
storm water drain, my lord.
The Korti Gram Panchayat accepted that encroachment, madam. In the statement.
Notice is issued or what?
Yes, madam. Notice has.
Some objections are filed.
Yes, Korti Gram Panchayat, they have filed the statement, madam.
That is. Where is the objection? Doesn't appear to be.
Yes. So Murugesh V. Charity. Temi Manjunath.
Any objections are filed?
My lord, it's the Gram Panchayat who has to initiate action, my lord.
Make a, make a- they will undertake the exercise as per your prayer.
Yes, sir.
They will survey and
And this case appear for the respondent number 6, my lord, Panchayat.
very good, welcome. So we will dispose it upon by directing that. You undertake the survey and find out encroachment if any.
My lord, it's a Panchayat who has to do.
Panchayat.
My lord, in
The
turn, we are
Panchayat-
also write a letter.
You are omnipresent. Panchayat.
No, no, my lord, my lord. My lord, if my lord were to direct me, my lord, then I'll see that the
Yes,
DC
but who is
initiates.
for Panchayat?
My lord,
For Panchayat,
Panchayat, my lord.
you undertake survey. Find out whether.
Regarding to conduct a survey, we write a letter to the respondent, deputy commissioner, and assistant commissioner.
Pursue that letter. They will undertake the survey and do the necessary, if it all required, right?
Sure.
Dispose of. Your Kalyan.
That is annexed D, my lord, we recommended, my lord, for the deputy commissioner to conduct the survey, my lord.
You have filed something, your objections are filed,
No, my lord, I have less time to.
we'll do that. We'll ask you to undertake the surveys and pursue the letter you addressed.
Yes.
Next.
So number 33, Mr. Richardson.
This is a case where I've been quarrying stones from my land and using it on my land. And under Rule 3A, I don't have to pay royalty. They have been continuously issuing me notices. My lord, here it has come before your lordship on 4 occasions. Twice it didn't reach for paucity of time. Twice it reached. The government keeps taking time. They take time here. Parallelly, they go there and issue a demand notice. But what is happening is I'm paying money under protest so that the work keeps going. But how long will I be able to sustain paying 60 lakhs, 70 lakhs at each time? Now up to end of March, I have paid under protest. I have sought for an interim order to say, don't collect royalty from me. I'm taking it from my own land. There is no dispute about that. I'm using it in my own land. There's no dispute about it. They rely upon an Orissa judgment of the apex court. There is no such provision in the Orissa laws. And also there it relates to where no quarrying license.
Well, our notices have been issued, reply has been given. We want to hear them before passing an order. My lord, I'm filing a memo, my lord, wherein a final notice has been issued on 11/11/24. My lord, they may appear before the
My lord, on 6th
officer
November,
concerned, my lord, and then let there be an adjudication on the
my lord,
notice.
6th November, they come here and say, give us 2 weeks time to file objections. 11th, they go and issue a notice. I've just got it 2 days back.
No, 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 no. On 5/11, petitioner's counsel sought for time. I didn't seek.
Sir, counsel for respondent sought for time. It's here.
You filed an appeal.
But now notice is received, you reply and.
No, notice that notice has been coming for the last 3 years. We've been replying to them. NHA has replied to them saying that, listen, please have a look at your Rule 3A. It is not that you can't simply go on harassing us. They bring the police, seize our equipment, they stop work.
My lord may fix a date for hearing and we will decide that in accordance with law.
They will not, they will know if no coercive steps.
No coercive step till then. My lord, one request, my lord. May I request, if I may take the liberty, my lord, let this writ petition be there. I'll go before them. I don't want to multiply proceedings again, my lord. My lord, what will happen is I'll go there. They'll pass an order adverse. Again, I have to come for one.
My lord, if an order is passed, they'll have to challenge that order.
So I can at
This
least
is
amend
at
this
the
again.
stage of
My lord,
notice.
Raise cause of.
Yes, my lord. My lord may see the prayer.
What is the prayer letter?
Page 53, my lord. 58, main prayer. I've sought for quashing of the notices saying that it is beyond your jurisdiction. We don't fall under any of these categories. 6 identical notices. Time and again, just issue that notice, refer to the Orissa judgment and say pay. Even though I tried to explain, there is no attempt even to answer what I am saying.
So these are the notices asking for penalties.
Yes, my lord, they've given a reply. We have called upon them to come and, my lord,
But from
urge whatever the
23 I've been
contentions
doing-
they want to urge.
After that, I filed this writ petition. Thereafter, they asked for time, saying that we'll file objections. We pointed out that it's not as though it is some gray area. It's Rule 3A says if you're doing it on your own land, using it for your own land, you don't need, all that you need is a working permission. My working permission is there till February of 2025.
My lord, if we don't give them an opportunity of hearing, they say there is violation of principles of natural justice. My lord, when
But
we
this
come
seems to be
forward
the
before
latest
my
one. They
lord
appear
and say
before
that
us.
we will hear them out.
They're pushing it back to square one, my lord, where we've been trying to tell them, listen, this is not there. They could have at least called us after we issued the first notice, when we replied. Again, they issued the second notice. They seized the machinery. They got police to take.
No,
But-
that is not word here.
We'll dispose.
My lord, they have never asked us to come for a hearing till today. Now, this is the latest one so that they can get out of this now. I have to go back.
Sir, I think
No.
they'll be polling the.
My lord, I don't understand if you give them an opportunity
my
of
lord, what-
hearing
my lord,
they
with great
oppose.
respect, my lord, they're
My
not
lord,
doing
they want
charity, my lord.
notices to be quashed
My
without.
lord, they are not doing charity to me. When they first gave me a notice in 23, I replied, you should have said, I'll give you a hearing. No.
How they are stating that notice is given. 11/11. Copy is available.
Yes, my lord, I have given a
We've
copy
just got
to
the,
my
we've
lord.
just,
It's
we just,
served.
we
Now
got it now.
you are posted with knowledge of the notice.
Pardon?
You are posted with the knowledge of the notice.
Yes, I've got notice. There's no.
You appear and they let you.
Yes, my lord.
But identical notice to what was issued 1 year back.
Let them take that same contention, my lord. Let the
My lord,
officer
please see.
know.
My lord, this is ingenuity, my lord.
No,
Writ petition pending here, take time. Now can't take any more time. I issued notice, let them come and answer me. My lord, you could have done it in the first instance in November of 23. Who would have even come before this court? So much of papers. It was just a.
My lord, I
The hard learned senior advocate is always vehement in.
No, my lord. My lord, it's only a question of interpretation of Rule 3A, my lord. What is it? They're not going to interpret, even though we have told them.
In the stage of notice, you know that we will not interpret. Nothing is adjudicated, so there is nothing to decide for us.
Well, but we have to pay royalty. That's the problem now.
We are saying that no course.
Very well. Grateful, man.
Yes.
Lordship may fix it. Your lordship may fix a date. We'll appear and
The
close
third
this.
learned senior advocate, Mr. So-and-so, assisted by learned so-and-so, and learned additional government. In law for record, the respondent authorities, the petitioner are the group of companies engaged in the construction of roadways, highways, and public infrastructure. So the petitioners are aggrieved by various notices issued by respondent mines department.
I've lifted them out at page 58, my lord, full list.
Which are the notices 1, 2, 3, 4, page 11, instead of ABC, 1, 2, 3, 4. Up to. The prayer is made to set aside the page notices. It is further prayed to.
Page 58. 58, my lord. That's the prayer is the main prayer. The notices are all listed there.
Injunct the, to restrain this one from acting upon the due notices of like letters. And doing any, and proceeding with any action which would lead to stoppage of the construction work at the sites of the petitioners. The petitioner wants a declaration from the court that the royalty amount of ₹74,38,000 collected by the respondent is illegal and without any authority in law. Full stop. There is no gainsaying that the jurisdiction of this court under Article 226 was invoked in respect of the notices which are yet to be adjudicated. The petitioner is as such premature, since the petitioner will have right to reply to the notice and raise all the defenses available in law. In course of the hearing of the petition today, from a learned additional government advocate, files memo dated 9/12/24 on behalf of the respondent 1 state of Karnataka, in which it is stated that notice dated 11/11/24 is issued by respondent 2, Deputy Director, Department of Mines and Geology, Tumkur District, to the petitioner, and that the respondent competent authority proposes to proceed to
Before whom should we appear?
adjudicate the notice after calling the petitioner.
Yes, well, a
Submit its
notice.
reply.
Yes.
So, the submission is fair, since the notice issued to the petitioner will be permitted to be responded to by the petitioner, and the petitioner will be permitted to raise all the defense with regard to penalty proposed to be imposed by the notice. As the respondent have shown readiness to proceed to adjudicate notices, this petition is disposed of by issuing following directions. Paragraph. It will be open for the petitioners to file reply to notice dated 11/11/24, as well as any other notice earlier issued, which shall be done within period of 3 weeks
Yeah, man.
from today. Paragraph.
Lord, before whom should we appear now, my lord? Now, don't they say you appear before whom I should appear?
My lord, the person who's issued the notice.
Director of Mines and Geology.
The Director of Mines, respondent
My
1.
lord, the deputy director.
Deputy Director, notice is by
He has issued the notice.
the Deputy Director of Department of Mines.
Department of Mines and Geology.
Tumkur.
Shall consider the response of the reply of the petitioners to the said notice, and shall proceed to adjudicate the same by taking into account all the points which may be raised by the petitioner.
My lord, one submission, my lord.
First of the petitioner may be given the opportunity of hearing.
Yes.
And one submission, since the state is also involved as claiming, it could go before the office of the Director Mines and Geology at Bangalore itself. First respondent, state.
The notice issuing authority.
Let him take that contention, my lord.
No, I am not, I don't want to fight. I want to go on with my work and complete my highway project.
Apply with this one. And proceed to adjudicate the controversy by all the full stop. Necessary decisions shall be taken in accordance with law and on merits within a period of 8 weeks from the date of receipt of the reply. Paragraph. If the petitioner applies, will give the hearing opportunity.
Yes, my lord.
If the petitioner applies for the personal hearing, the opportunity will be given by the Deputy Director, and the petitioner will be heard in the matter. Paragraph. The entire exercise will be completed within thereafter 8 weeks from the date of receipt of the reply of the petitioner. Till the final decision is taken next. No precipitative action shall be taken against the petitioner.
Well, one more request, I may be permitted to make a request for refund of monies paid under protest. That may also be part of the order, so that.
No, first of all, my lord, an order has to be passed.
No, that's okay, but I will make it in the same representation I will ask, because prayer C of the writ petition is also that.
At this stage, learned senior advocate submits that the petitioner is entitled to refund. Full stop. Such contention may also be raised before the authority. However,
Yes.
the same shall be considered, and it shall be decided whether the petitioner is entitled to refund of the amount as claimed for, in accordance with law. Full stop. The said part shall also be dealt with, exercise to be undertaken, and decisions will be rendered in that regard also. So this court does not express any opinion in respect of the merits of the case of the petitioner on either aspect. The petition is disposed of the court.
Obliged, my lord.
My appearance for respondent number 2 may please be marked.
You appear after disposal.
My lords, I was appearing since the beginning, my lords. I did not interrupt the court, my lords. Please, my lords.
Who? Who?
34, Mr. Raja Ram is 34.
My lords, I am appearing for respond number 5 and 6, my lords. I have filed wakalat for 5 and 6, respond number 5 and 6 on 2011-2024. My name is not shown in the cause list, my lords.
Responses are filed, replies are filed.
No, my lord. It's to consider the directions and a direction to the owners of the chicken-based processing unit to shift it from the place where it is near the, to outside the limits, my lord.
My lords, I am appearing for.
My lords, I have. My lords, I.
Please.
My lords, my lords, I appear for 7 and 8, my lords. I may be allowed to file my objections, my lords, by next day.
But you are appearing for whom?
I am appearing for 5 and 6, my lords.
5 and?
Respond number 5 and 6.
5 and 6.
Yes, my lords.
The replies to the petition, though directed in order dated 12/11/24, are still awaited to be filed by the respondents concerned. The same shall be filed before the next date. In the meantime, the official take on record, if not taken, the wakalatnama filed on behalf of section 5 and 6, and mention the name of learned advocate Mr.
Ketan Kumar, my lords.
Ketan Kumar, while notifying petition on the next day.
Please.
Stand over to 13th February.
Number 35.
For respondent, my lord.
Appellant before your lordship is Hubli Electricity Company, my lords. The writ petition was not maintainable, my lords. While allowing the writ petition, not only the writ petition is allowed, a cost of 5 lakhs has been imposed on the 5 lakhs cost, my lords. In fact, my lord, under section 86 of the Electricity Act, my lords, the author power is with the KERC, my lords, to adjudicate the dispute between the petition appellant and the respondent. That was the preliminary objection which was raised before the learned single judge.
For the regulatory commission.
Please, my lord, 86F, my lord. I may permit it.
It is section 86.
Section 86 of the Electricity Act.
My lords, we have just come on record. We have filed our wakalat only on 27 November. My lords, may allow me to file my objections to the main matter and even the application for condemnation of delay.
No, 6 days delay, I think.
There's some
48 days. 47 days.
My lords, it's well within my right to file objections to that application, my lord.
You file, but we'll stay this cost part.
Only the cost part.
Sorry, my lords?
We'll stay the cost part.
My lords, may allow me to file. My lords may give me 1 week at least. I'll file my objections.
No, cost part will stay. There is no point in imposing cost. Forget about the merits. 5 lakhs cost for what?
I'm in my lords.
Learned advocate so-and-so appears and request to permit. Among the respondents.
Government.
There's a notice is issued.
Notice has been issued, my lord.
The appeal is required to be admitted. Full stop.
My lords, one small request, my
Which shall
lords.
be listed next on
My lords, the application for condemnation or delay.
17th January.
The appeal may be admitted after the application is adjudicated.
Delay is there?
48 days.
48
In fact,
days
my
is
lord,
there.
your
Please
lordship.
allow me to file my objections to that.
Then only.
Please, my lords. On the next date of hearing, I'll ensure all the objections are filed. And the matter, even on merits if required, may be taken up. And if my lords may adjudicate at that
On
point.
8th of January. Notice must have been issued.
Your lordship that issued
I'll-
notice, after notice, my learned friend is appearing.
Please, my
Can
lord.
we condone the delay? If you are appealing.
My lord's notice even for the application was issued, my lord. The notice even for application was issued, my lord. My lords will say order dated 28/8/2024.
In fact, your lordship wanted to stay the matter initially, but then your lordship noticed that there was a delay
Your lordship issued notice on delay as well as the main matter.
Please, my lords. So allow me to, my lords may allow me to file objections to those things.
In fact, if my learned friend is insisting so much, I have no option.
Notice was issued on 22/8/24 by the court, both in the application for delay condonation as well as in the writ appeal. Full stop. Learned advocate Mr. So-and-so appears and prays for filing vocal. Full stop. Vocal is going to be filed within 1 week. Full stop. Delay is of
48 days.
48 days, which is sufficient.
47.
47 days, which is sufficiently explained in the supporting affidavit. Therefore, delay is condoned. Application for condonation delay is allowed. Full stop. While passing order dated 22/8/24, contention on behalf of the petitioner raised by learned senior advocate Mr. Kiran Shetty was noticed that that learned single judge was not justified in exercising the jurisdiction when the subject matter dispute was tried to be adjudicated by the alternative forum created in statutes, namely the Electricity Regulatory Commission under section 86(1)(f) of the Electricity Act 2006. Full stop. Appeal deserves final consideration, therefore it is admitted to be admitted to be listed on 5th of March. Within which time the local announcement shall be filed. Full stop. The appellant is obliged, applicant shall not be obliged to pay the cost till the next, during the event. Pay the cost.
Please.
By way of interim, it is directed that the appellant shall not be obliged to pay.
Grateful to you.
Number 36, Vijay Kumar.
On behalf of the advocate for the. This is a revenue matter where I am the original allottee of certain land. The contesting private party has been granted land in the same survey number which overlaps mine. Consistently, this court at various stages in the litigation has held in my favor. Revenue authorities seem to be passing orders against me. Pleadings are complete, synopsis has been filed. I may take it up either later today or on a date which is fixed, but we'll finish.
Some other day.
Short point is only this, my lord. These courts, various orders in my favor. Revenue authority simply ignore. In fact, my lord, at one point in July, the matter had come up before this honorable court. And your lordship had directed that the state government should verify the original records.
It was heard?
Partly, just briefly by my lord.
When you are ready.
We have secured the records, my lord. We have, in fact, a stand has been taken, my lord, page number 52. Connected
No,
writ
that
appeal,
is
my lord, an
you
affidavit has
ready?
been filed regarding the genuineness of the grants. 10th March, 10th.
16th January.
16th? Very well.
Very well.
Grateful. Interim orders to be extended.
Interim order is there. 10 to 16th January, interim order, which is already operating, shall continue.
Grateful.
Next.
Great.
Court officer? Court officer ಕೇಳಿಸಿದ್ಯಾ? Court officer?
ಹೇಳಿ ಸರ್, ಏನ್ ಹೇಳ್ಬೇಕು?
ಇಟ್ಸ್ ಸರ್, ಇವರು ಸಾಹೇಬ್ರು ಲಂಚಿಗೆ ಆಮೇಲೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಕೋರ್ಟ್ ಹಾಲ್ 1 ಅಲ್ಲಿ?
ಫಿಟ್ಟಿಂಗ್ ಇದೆ ಸರ್.
230 ಮ್ಯಾಟರ್ಸ್ ತಗೊಳ್ತಾರಾ, ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಾ ಸರ್?
ಬಂದ್ಮೇಲೆ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್.
ಓಕೆ, ಆಯ್ತು. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ಸಾರಿ.
ಹಲೋ, ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸ್. ಹಲೋ, ಕೋರ್ಟ್ ಆಫೀಸ್.
All mentioning.
Yes.
Serial number 104.
Serial number?
104. It pertains to Gauri Bidnoor, establishment of court at Gauri Bidnoor. What happened in 2023?
It pertains to?
Establishment of court in Gauri Bidnoor Taluk. In 2023, the invitations, everything was ready, my lord. Then they filed a writ.
But then it belongs to which bench? Our bench?
Yes. Today it is there.
In
It is there. It is
Morning
the,
bench.
oh, it is a morning bench. Oh, all right. I'll mention it when please, my lord.
Your Lordship's kind permission, the memo for posting, my lord, this contempt petition came to be disposed of with an undertaking. However, they have not complied with it. Your Lordship's, this roster bench had passed an order. May I
This
re-
bench?
Yes, my lords. May I request for any date?
We thought you were sitting sneaking otherwise.
Lordship,
What is this?
My lords, this is a contempt petition that came to be disposed of as per the undertaking given, my lords. However, they did not abide.
Whenever we sit next time?
Very well, very well.
This may be listed.
Great.
Lordship, serial number 105.
10.
Contempt petition coming for the 6th time. They are not filing. It is not reaching my lordship.
Another bench. Soon after the constitution.
Seal number 1, review petition, Mr. Chandrakant Argole.
See the order under review. Page 40. Page 40, my lord.
Removal from service.
Lords, he retired, my lords.
Retired.
It is not removal from service. It is reduction to, my lords, the next lowest stage. From the post of, my lords, Deputy General Manager to Assistant General Manager.
After notice it has come.
Yes, my lords.
Yes. It,
For orders.
Lords, may
Whenever we list sits or we'll assemble for the purpose of passing the orders.
Lords, your
Like,
Lordships
you
are
want
posting
to
for
submit?
orders, my lords.
You want to submit any?
Please, my lords.
Yes, submit, please.
Please. Please. Lords, the grounds, my lords, which has been urged, lords, either it was raised, my lords, when the writ appeal was argued, and as well as, my lords, some of the grounds which they have raised, my lords, which were not part of, my lords, the writ appeal memorandum or, my lords, the pleadings. My lords, kindly see, my lords, when the order is passed by this honorable court, my lords, whether they have made out any grounds, my lords, for review. My lords, so far as the review jurisdiction, my lords, is concerned, my lords, the Honorable Supreme Court.
But we have adopted Order 47, Rules 1 and 2 by virtue of Rule 38 or 39 of writ proceeding rules. Therefore, it is not as restrictive as the apex court said in that judgment.
Lords, generally, my lords, the exercise of power, my lords, of review, either, my lords, it falls under, my lords, section 114, my lords, or the nature, my lords, or the power exercise, my lords, is akin to Order 47, my lords, Rule 1. My lords, so far as, my lords, this issue is concerned. Now, kindly see, my lords, there are totally 6 charges, my lords, that has been
We have
leveled
not-
against.
Have you reviewed? Have you reviewed the judgment? We do not know what we will do.
Lords, I would like to, lords, make submissions because, my lords, later on,
You are welcome to submit.
it should not be, my lords, that I have not addressed the arguments.
You are proceeding on the assumption that we are going to review. There we can't say until the judgment is delivered. Nobody can say, even we can't say.
My lords, after the release of judgment, my lords, my remedy, my lords, will be elsewhere, not here.
Keep this mind and submit, yes.
No. Please, my lords, please. My lord, because, my lords, once the order is released, my lords, then I will not be in a position to, my lords, that is why, my lords, I am making this submission. Lords, there are totally 6 charges, lords, which were leveled against the appellant, lords, the review petitioner hearing. Lords, 3 charges, lords, the charges insofar as 1 to 3, and lords, 6 is stated to have been proved, lords, after the holding of inquiry. Lords, 3 charges, lords, pertains to serious, lords, insubordination. One is, lords, with regard to, though the allocation of work, lords, is done by the managing director, not giving effect to that. Lords, once again, lords, the reallocation of work is done. Even, lords, that has not been given effect to. And contrary to that, lords, he says that I am not going to implement that, since I have been instructed, or, lords, I have written to the government or the, lords, the minister concerned. Till such time, lords, it has to be maintained in status quo. And, lords, that is the such letter, lords, that has been written by the petitioner here. The another, lords, aspect is that when he was supposed to attend the meeting, lords, called by the government, he says that he could not attend the meeting, or he left early for the reason that he was supposed to go to his native along with the family. Lords, all those, lords, issues have been taken into consideration. And another, lords, important aspect is that he kept on, lords, writing letter to the state government for one or the other reasons. Lords, in each and every, lords, instructions, when it was given to him by the, lords, managing director, he did not obey it. And contrary to that, lords, straight away he approached the state government or, lords, the minister of the department concerned. All those issues, lords, have been taken into consideration while imposing the penalty. Lords, the penalty is imposed under Rule 816, lords. Rule 816 clearly specified that, lords, reduction to a lower stage time scale of pay, grade or post, which shall, unless otherwise directed, be a bar on the promotion of the employee to the time scale of pay, grade by post from which it was reduced, or with or without further directions regarding. Lords, here, during the pendency of the proceedings, lords, before this honorable court, he retired from service. And, lords, there is no question of, lords, he being reinstated or, lords, position to the post of Deputy General Manager. Only one, lords, the punishment to the next lower stage, lords, that is from the post of Deputy General Manager to the post of, lords, Assistant General Manager. In fact, lords, the kind of the, lords, the charges leveled against him, lords, it should have been beyond that. But however, lords, the authorities have not taken into, lords, the other aspects, and they have, lords, reasonably imposed, lords, the punishment to the next lower stage.
So what is the penalty?
Lords, the penalty, lords, is to the next lower stage of
lower-
scale, and yes.
And the misconduct was of insubordinate.
Insubordination, not attending the meeting, not giving effect to, lords, the directions issued by the managing director.
And writing a letter to the.
Letter to the government, lords, that is bypassing the managing director, lords, because it is a company, lord, it is not, though, lords, it is a government company, but it is not under the state government. May I just point out, lords, the documents, lords. Appeal copy. Appeal. Lords,
Papers,
appeal papers. Appeal.
We'll sitting again in some particular day, in near future.
Very well.
At that time you can,
Please,
to your satisfaction.
please.
To be discussed whenever.
Bill number 2. Kavita Damodar.
I appear for the review petition, Your Lordship. Your Lordship, we have filed a memo for withdrawal in the matter.
Withdraw.
On 29/11, there's a memo for withdrawal filed.
Read the memo. Figures on record. Memo dated 29/11/24, whereby learned petitioner seeks permission to withdraw.
Withdraw the
Present review petition. Permission is granted, dismissed as withdrawn.
brief.
Yes. CL number 104, my lord.
What is it?
Yes, my lord. This matter pertains to establishment of court at Gauri Bidnoor Taluk, my lord.
Court.
Court, my lord, establishment of court. What happened, my lord? Invitations were printed and it was about to be inaugurated. At that time, one of the grantees, the grants were all rescinded, forfeited. One of the grantees filed a writ petition. Therefore, the inauguration was stalled. Then the writ petition was dismissed, holding against the grantee that the forfeiture was valid. Against which, interestingly, they have filed a writ appeal just for the purpose of filing without paying sufficient court fee. Matter came up 4 times before the registrar protocol, 3 or 4 times. 4 times. They did not pay the court fee. Landlord, simply they want to keep it pending.
The office of the counsel. Who is here? Who is there? Appellant
Counsel appearing for the appellant is not here. my lord.
104.
104.
So in all office objections matters, which starts for non-compliance for 4th time. 4th time. So we are granting 2 weeks in all matters, which is 4th time. 4th time and 5th time. Oh, 6th time.
Yes, my lord. 4 times and above.
7th time. So it is in for 5th time, ne? This you are.
Yes, my lord.
mentioning
5th time.
104. So
We are-
wherever it is 4th time, 4 weeks. 5th time, 3 weeks. 6th time, 2 weeks. 7th time, 2 weeks. All common order. 2 weeks to 3 weeks, 4 weeks time is granted to remove the office of this. In this 104, 3 weeks time is granted to remove the office of justice, which includes non-payment of court fee of ₹800. It was pointed out, though it appears that court fee of ₹800. It is provided in all matters. If the office of is not removed within the stipulated time as above, the appeal shall stand automatically
Please.
dismissed
Please.
without reference to or order of. law.
Please,
In all matters.
please.
Your
Oblige.
Lord- Your Lordship, serial number 37, Your Lordship, I'm appearing for the appellant. I request for a short accommodation, Your Lordship.
Which one?
Serial number 37, Your Lordship.
37.
Yes, Your Lordship.
37. Next is next due. Next matter. What do you want time?
Any short accommodation, Your Lordship.
Court will not be, that will go in January, February.
In, maybe had in the first week of Jan, Your Lordship, subject to convenience.
January, 17 January.
Much obliged, Your Lordship.
Lordship, serial number 105, my lords. 1/6th time it is coming for,
Now it is already passed. 2 weeks, within 2 weeks you remove. Otherwise it will automatically dismissed.
Logic 39, not seen of 39.
But 39.
Please, short accommodation required.
So what is the time?
Please, short.
February, 3rd February.
Passover matter, cell number 15. Mr. Shekhar L.
Learned advocate was absent in both the courts. However, in the larger interest of justice. On 8th of January.
So 230 matters, cell number 116 for withdrawal of writ petition. Mr.
May it please, my
Manish
lords, I appear for the petitioners, my lord. My lord, could I seek 1 week's indulgence, my lord, because they are still considering my representation before them. 1 week's indulgence, my lord, next Monday. No, we have filed for a memo for withdrawal.
It will go to 16 January.
Grateful, my lords.
The 3rd February.
My lords, 3rd February is too far off. I'll.
It will go to 3rd February. Yes.
Number 117.
I appear for the petitioners. Your lordship consider having it after vacation.
What is it about?
This is that PIL, my lord, which is an old PIL with respect to that layout called judicial layout. Where there's a report. I was only wondering.
Cooperative society.
Cooperative society.
So what survives?
There are some issues which I think will not survive still.
All right. But you have filed your reply.
Everything is filed.
Report is also submitted.
One report is submitted. I don't know the translation has been handled.
Yes, yes, it's been given.
So much water has flown.
The long water has flown quite a bit. There's no doubt about that. There's a lot of water.
Whenever you want.
Immediately.
Not too far, but
Yes, sir.
4th February.
My lord?
4th February.
Yes.
Lord, I have filed 2 applications for impleading, my lord. We are the associate members, sir. Could be
You
tried
filed
out.
impleading in some 2024, man. We'll see on that.
Yes.
Number 118. Just Syed Palim
Your lordship, 447 delay in filing the appeal. 447 delay. This delay.
Delay. Who appears? Notice.
Applying for the state, my lord, this is.
This is the.
SCST matter.
SCST. In your lordship, in writ up.
You have dismissed all matters on the ground of laches.
In WA number, writable number 210 of 2023, order dated 21/8/2024. This Honorable Court was pleased to condone the delay in all the matters. I will produce the order copy, your lordship. Writable number 210 of 2020.
All matters you have dismissed on the ground of delay. So there is no point in condoning delay. What you are talking is before the decision of the Dharwad bench.
In lordship, grant urgent the matter, I will produce that copy.
Produce copy tomorrow. Tomorrow.
Tomorrow, no, your lordship. 1 week time may be granted, your lordship.
1 week can be granted. Day after tomorrow. Day can be granted.
On 13th, your lordship. 13th.
13th at 2:30. 13 if you are not present, we'll dismiss it.
Yes, your lordship.
Yes. Time is granted at the request of learned advocate for the petitioner up to 13th of December. It is clarified that the court shall proceed on merits on that day, even if learned advocate for the appellant is not present. If there is no ground not to present.
I will produce the copy.
Don't run away. Don't run away.
Yes, yes.
Yes.
Number 119. Harsha Kumar Gowda.
I appear for the appellant, my lord.
I appear for respondent number 7.
My lord, the appellant. My lord, the appellant grandfather was granted with the land under the Gromor Food Schemes, my lord. My lord, kindly see, my lord, the appellant grandfather by name Bailaya son of Kadlingaya, my lord. But my lord, one Bailappa son of Timappa has executed the sale deed in favor of one Venkateshaya, my lord. The one Chennaya, the GPO holder of Chennaya has executed the sale deed in favor of the respondent number 7, my lord. My lord, the Supreme Court order says that, my lord, appeal to the Assistant Commissioner is not maintainable under the PTCL Act, my lord. But before that order came into pass, my lord, the appeal has been filed, my lord. In the year 2008 itself, the appeal has been filed, my lord. And my lord, here, my lord, Till 2007, my lord, the RTC was stands in my name, my lord. They says that we have sold the property in the year 1970 itself, my lord. But till today, till 2006-7, my lord, the RTC stands in the name of the petitioner grandfather, my lord. I have produced that annexure G, my lord. The writ petition has been dismissed only on the ground that the appeal is not maintainable before the Assistant Commissioner under the PTCL Act, my lord, for the land granted under the Gromor Food Schemes, my lord. But on the merits, I have the case, my lord. Only on the technical ground, my lord, the appeal was not maintainable, they are said, my lord.
It is not a granted land within the two. That's the point. It is not a granted land within the meaning of section 2B of the Act.
Yes, my lord.
Therefore,
Here, my lord, in my matter, my lord, one Bailappa son of Timappa who impersonated the signature of the appellant grandfather and executed the sale deed, my lord. That is my case, my lord. If my liberty is granted to me, my lord,
land taken under lease.
now the land is acquired by the KIDB, my lord. Till acquisition of the KIDB, my lord, I am in the possession of the property, my lord. And with respect to the granted land, my lord, they have to take the prior permission, my lord. They have not taken the permission. And within 15 years, they have sold the property, my lord. By considering all this aspect, my lord, the Assistant Commissioner has allowed my appeal, against which they preferred the revision to the Deputy Commissioner, my lord.
That's para 8 of the impugned order, please, page number 18. The identical matter has been disposed of by the Honorable Supreme Court. In Nanjamma case, please.
Act of Najamma, this is Act. It is section 3B or 2B? Granted land is 3B.
2B, please.
3B.
2B of PTCL Act.
इसमें तो 3B है. Definitions in section 3. Third learned advocate, Mr. So and so for the appellant. From a learned assistant government, learned additional government leader, Mr. Harish for the respondents number 1 state. 1 and 1, 2 and
1 to
1 to
4.
5.
1 to 4.
1
Five
to
is
4.
special land acquisition.
And learned advocate, Mr.
Respondent number 7.
Respondent 7. The appellant is the original petitioner who has preferred this appeal under section 4 of the Karnataka High Court Act 1961. Seeking to call in question judgment and order dated 1st April 2024, whereby learned single judge dismissed the writ petition. In the writ petition, the prayer of the petitioner was to set aside the order dated 21/4/23. Passed by the deputy commissioner, that's this one for 4 years, and thereby to confirming the, consequently to confirm the order of the assistant commissioner. It was further prayed to allow the application of the petitioner for restoration of the granted land in his favor. Restoration of the granted land in his favor.
Easy dismissal.
The facts pleaded by the petitioner was that he belonged to backward community, that his grandfather named Bailaiah, P-A-I-L-A-I-H, son of Padalingaiah, was the original grantee of the Telecast land bearing survey number 214 into bracket old survey number 46/P19 bracket over, at measuring 2 acres, situated Obalapura village, Yama Guddalu Hobli, Nelamma Vella Taluka, NELAMAG, Nemangala Taluka, Bangalore Rural. The said land was leased to the petitioner's supposed to be his grandfather under the scheme known as Grow More Food, GMF Capital. The name of the grantee was entered in the revenue records. Name of the grantee and his heir, Bailaiah, B-Y-L-A-I-A-H, continued to figure in the revenue records till 1/7/1970. Paragraph. Bailappa, B-Y-L-A-P-A, executed registered sale deed in favor of one Venkatesaya. It was the case that the said Bailappa was not the family member of the petitioner and had nothing to do with the property to be sold in favor of Bailaiah, B-Y-L-A-I-H. The property passed the hands even further. Ultimately, not ultimately, finally sold in favor of, finally came in the hand of Disciplinary 7, in whose favors the entry was mutated. The petitioner invoked the provisions of PTCL Act, seeking declaration that the sale transaction was null and void and that the property was liable to be restored to him under the provisions of the Act, since he was a grantee. Since his forefathers, since he was a grantee, having stepped in the shoe of forefathers. Learn a single judge paragraph. Noticed that it was an admitted fact that the land was granted under the Grow More Food scheme. And was not a granted land in comma, within the meaning of section 3 into bracket small b of the Karnataka scheduled caste and scheduled tribes into bracket prohibition of transfer bracket of certain land bracket or act. Paragraph section 2 full stop. The view was taken that since there was a sale transaction in respect of a land which was not a granted land, so as not to attract the provisions of the PTCL Act. It was rightly held that the said aspect was not considered by the authority who passed the impugned order. The last sentence. The definition of granted land occurring in section 3 into brackets small b of the Act reads as under. Then quote the definition, granted land, yellow left. Paragraph. Therefore, the granted land under the above definition, comma, therefore, comma, the granted land would include the land granted by the government to a person belonging to scheduled caste or tribe, and would include the land under the relevant law relating to agrarian reforms or land ceilings or abolition of in-arms, other than that relating to the hereditary office. It is stated in the affidavits, it is provided in the definition that the word granted, inward comma, shall be accordingly construed. Paragraph. It is observed on facts by a single judge that the land in question in the instant case was taken under Grow More Food scheme, which was thereafter leased in favor of the grantee at an upset price of ₹100. This is reflected from the document at Annex A, reflected from the certificate at Annex A. Document at Annex A as well as the certificate figuring at Annex B. The land paragraph therefore could not be considered as granted land, inward comma, within the meaning of the aforesaid definition, so as to attract the provisions of the PTCL Act. Response number 4 was justified in considering the said aspect to hold that the land granted in favor of Bailaia, B-I-L-A-I-A-H, would not fall within the definition of granted land. Full stop. No error was committed by a single judge in dismissing the petition. Any interference is not called for in the appellate jurisdiction. The appeal is dismissed.
Lord, liberty may be reserved to the appellant to file the civil suit, my lord. Because one.
Dismiss civil suit की liberty नहीं है.
My lord.
You can file, nobody prevents you.
Yes, my lord. The same may be observed, my lord.
Then withdraw and go. Withdraw and go.
No, let's.
Both ways you can't have.
No, the land itself is not there. It has been acquired by the KADB, please.
He can't
For
maintain this.
present, for the present, it
File
has.
civil suit,
Yes, ma'am.
then withdraw and file, we'll permit it. He said right now.
I will take instruction.
He'll
my
say
lord.
that.
I will
take
take,
instruction.
pass over, my lord, I will take.
All right. We'll call out at 4 o'clock. We'll call out at 4 o'clock.
Yes, ma'am.
No, my humble submission would be.
So write down alternative order also. You choose the either of the order. Learned advocate for the petition, Mr. So-and-so, after some amount of arguments, submitted that he would file a civil suit for seeking redress, seeking the redress of the grievance sought to be raised in this petition, without expressing any opinion about the merits or the merits of such recourse, the petition, the appeal is permitted to be withdrawn and stands dismissed as withdrawn. This is this order or earlier order? Choose. At 4 o'clock.
Yes, ma'am.
Yes. If you don't choose, the earlier order will remain, correct?
Yes, yes, I will inform to the officers.
Because every time not possible to remember your submissions. Yes, next.
Number 120, Mr. Srinivas V.
But I have to appellant in this case. But there's 428 days in filing the instant writ appeal, my lord. But this is with regard to the PTCL proceedings, my lord. The learned single judge have dismissed and have allowed the writ petition on the ground of Dikanti Lakshmi, my lord. There is a delay in filing the PTCL proceedings. On that ground, only on that core ground, the writ petition came to be allowed, my lord.
$51 years delay.
In filing PTCL proceedings, 1970 is the first alienation, 2010 is the proceedings initiated, my lord. Now, my lord, as per the new amended provision, my lord, there is no limitation, my lord, on the ground of delay. That should come to my rescue, my lord.
Sorry, dismissed. 51 is.
Instead of considering on that 428 delays on that ground, my lord. 428 delays in filing the writ appeal.
Say that there is no point in condoning the delay since the merit, there is nothing in the merit. That is how we will say. This is 120.
Yes, my lord.
Well, the present heard learned advocate so for the appellant and learned additional government advocate Mr. Harish for the respondent. Full stop. While the present appeal comes up along with the application, being IA number 1 of 24 for condonation of delay of 428 days, which has occurred in filing the appeal, available along with the papers, the impugned judgment and order of learned single judge. The court had enough benefit to go through the merits thereof. Then we'll narrate the merits and then in view of above, since there is no merit in the challenge to the judgment and order of learned single judge, no purpose would be served in condoning the delay. Accordingly, the application for delay is dismissed. Also dismissed consequently the appeal.
Much.
This is number 121.
I appear for the petitioner's counsel. Can I seek a week's indulgence? What has happened is, but though they've reported compliance, according to us, the compliance is not complete. There is a writ appeal that we have filed. We're expecting the numbering and the listing, my lord, by the end of the week or early next week. If your lordships are kind enough to, my lord, adjourn it by a week, we'll.
Lord, may I make one submission, Lord? Lord, may I make one submission in this case? We have complied the order, Lord. That compliance order was, Lord, challenged before the Lord learned single judge.
Last single judge, my lord, dismisses my lord petition of the writ
On the
petition,
ground
my
of
lord, on the ground
locus,
that, my lord, they
against
don't-
that, we preferred the writ appeal, my lord. That will come up before this court only, my lord.
Lord,
It's
there's
likely
no-
to be listed.
Lord, it's unfair on the part of my lord, the complainants. There, my lord, the complaints.
My learned friend wants to
Lord,
point
I
out
don't know, my lord,
fairness,
what-
let me point out.
I
Let me
don't-
point.
Lord, will ask him kindly see, my lord, the.
Let me point out, my lord. If my learned friend wants to say, let me make my submissions. If he really wants to press the point of fairness, let me, my lord, point out what their
Yes, my
conduct
lord.
has been.
They don't have, my lord, locus, my lord, to challenge, my lord, to keep this, my lord, contempt pending. Lord,
We'll see.
kindly see, my lord, the last page of, my lord, the judgment.
My learned friend really wants to press, permit me to make my submissions. It is rich that the
Lord,
respondent is
yes, my
pointing
lord,
out about.
challenge, my lord, the last single judge's order, my lord, let him challenge. We don't, my lord, object that, my lord. Why, my lord, this contempt,
I
my lord?
don't need my learned friend's permission to challenge that.
Lord, that's why, my lord, why this, my
Sorry,
lord, I
let me
contempt-
make my submissions,
Just-
sir. You made your point. Let me make my submissions if you're insisting. Please look at, my lord, the
necessary
order
to
of
keep,
the.
my lord, this contempt pending.
Complied with.
Yes, my lord.
No, my lord, according to us, it is not complied with. And the whole point is that the submissions made in the contempt petition and the reports filed here have a bearing in the writ appeal. That's the only reason I'm making the submission that this.
While there is a rival claim as to whether the erections under the relations of learner single judge are complied with or not. An aspect figures undisputed that in respect of the order brought under contempt jurisdiction, a writ appeal is filed, which is likely to be taken up at admission stage within near future. In that view, it would be right to adjourn the
So great.
proceedings to be listed on 13th January.
Lodge.
Time, whatever you want to do.
Please, my lord. Great.
Number 122.
My lord, in this, I seek my lord's apology, my lord. My lord, two orders which my lord was pleased to pass on 27th May 2024 and 19/6/2024. I seek my lord's pardon, my lord. Those have not been, haven't received instructions with regard to that.
Learned additional. government.
Lordships kindly, it's only writ in the nature of mandamus I'm asking. It's
that
against,
Forest and deemed forest.
that's what, forest land, your lordships. The application for safer zone is declared as patta land. Their own application, your lordships, may kindly read last occasion also, I read page 126 may be kindly looked into, your lordships. Page 126. Page 126 of the writ petition.
No,
your
let her take instruction.
Lordships, the reason is it's covered, your lordships. I'm just seeking writ in the nature of mandamus, your lordships, to consider my application. I filed application on 18/9/2018, your lordships. I'm in 2024. Still my application is not considered when all orders are in my favor. Page number 124, I'm just requesting this honorable court to see page 126. The translated copy is at 128, your lordships. It is own report of the Deputy Conservator of Forest, Range Forest Officer. Page 128, your lordships, relevant at page 130, your lordships. Last occasion also, I read the same. Page 129, para 2, your lordships. The said proposed area, survey number 200, in bracket 185/P. The original survey number is 185. The same survey number I'm seeking is a granted land. Is a granted land. And at page 130, your lordships, the last 4 lines. Further, as per so-and-so, there is a direction to retain so-and-so. Because of this, when it is a patta land, your lordships, and the area is declared, Annexure P is declared as a safer zone at page 119. The report obtained by the Deputy Conservator of Forest, Range Forest Officer, Senior Geologist have given this report. It's a joint inspection report. Page 119, Annexure P, your lordships. Status of land. Clause number 5, your lordship, status of land is a patta land.
Yes, what do you?
My lord, I'll get the report and
Let
I'll
them
place
take
it before my lord's.
Earlier.
Annexure P also, your lordship. Sorry for the indulgence because for 5 years over, your lordship,
My lord,
since
I'll place it
2018.
before my lord may pass any order. which my lord
2018,
pass.
there's already a report, your lordships. The matter is pending before the District Licensing Authority since 2022, your lordship. Only for asking again a report when there's already a Deputy Conservator of Forest is given saying it's not a forest land, your lordships, and it's a private patta land. Annexure P, your lordships, the status of land is given as private patta land. It's a joint inspection report given by the senior geologist, deputy conservator of forest, and range forest officer as per section 6 of the Karnataka Stone Crusher Regulation Act, your lordships. They've declared it's a private patta land. That's the reason my application is pending since 2018, your lordships.
Since we have passed the order requiring them to
Yes.
take a stand, let them do it.
Lordships, 3 occasions almost. I filed the writ petition in the year January 2024, your lordships.
Will it be
Lucky,
possible
my lord, she'll be able to get the order.
15th or 19th?
No, my lord, may I have it first week of January.
7th of January.
Obliged.
2:30, your lordships, I request.
Yes, yes.
There will be no 2:30 on the next.
Your lordships, the reason I'm requesting.
No,
Because
I'll
again,
get it, ma'am.
last occasion also matter did not reach. I made a mention, your lordships, it was heard
We'll take up.
Obliged, ma'am.
7th of January. Your lordships.
2:30 is not for giving preferences.
No, your lordships, I'm not asking that,
Those
your lordships.
matters
Only
which are touch and go matter or covered or complied with, those matters.
even,
Emergency. There is
Even
no
this is-
category, preferred category, 2:30, as you are, people are understanding.
no, your lordships, I'm just saying matter has been heard. That's the reason only it's a writ of nature of mandamus. I'm seeking to consider.
Every
my
matter is
application.
equal, but if it's to be touch and go, covered matter, something is complied with. We are, so that it can be disposed of. That is how to 2:30 category. There is no preference or priority. Next,
Obliged, ma'am.
7th of January, your lordships.
7th Jan.
Number 123, to Vishwanath Shetty.
The respondent in this case, my lord, the last occasion, your lordship was pleased to tell us on maintainability. Any judgments on this point, my lord?
Before my learned friend starts the matter on merits, my lord, I have placed on record the appeal filed before the company law tribunal against the order of the registrar. Notice was issued to ROC and the matter is posted to tomorrow against the cancellation of my registration.
Lord, this appeal is filed on 18/7/2024. Before NCLT, appeal is filed on 27/9/2024 after filing of this appeal and after we took the ground.
But the issue you both are harping is now being dealt with by the, so why not wait?
Lord, the pendency of the proceedings before NCLT is, it has no bearing on this
Carry
aspect.
point, 20th January.
See, there is, the Delhi High Court Division Bench has given a ruling on the similar circumstance. Pendency of, there is no stay order.
Whatever tribunal takes a view, that judgment will not be wiped out. We'll consider on the next. Yes.
Huh? Even otherwise, we have other merits also. An early date may be fixed.
It's quite off.
It's more than 15 years, my lord. 5 years.
From 2020,
We'll consider.
more than 20 years.
We'll consider. Next.
Any date in
Lord,
first week,
may-
my lord.
First week of, immediately after vacation, after reopening, a date may be fixed. 8th or 9th.
I will convey.
13th. will come. 13th.
My friend is here.
13th.
13th, much. 13th.
My lord, may I request one hearing, my lord? Serial number 86, my lord, that is arising out of a section 9 petition. The interim order of invocation of performance.
Which?
86, my lord. 86.
This is, you can't mention the middle of the board.
My lord, there is
It will be called out.
extreme urgency, my lord, that's why.
What urgency?
It's against, I sought an interim order against invocation.
Can't mention when the board is running, Mr. Counsel.
Please.
How can you mention in this?
Seal number 40,
There must be some order and discipline, yes.
so Mahesh Chandra BN, seal number 40.
Lords, I appear for the appellant, my lords. There is a delay of 41 days in filing the appeal, my lords. Notice has been issued and it has been served. And the council has filed wakalat, my lords. The matter wherein, my lords, a B group cadre employee gets into a post of C group and
40 is not mentioned.
I'm
So who
seeking-
appears?
Lords, he had appeared for serial number 121, my lords.
Srinivas V.
It's a matter wherein, my lords, the first respondent is a person belonging to B group cadre, my lords, and
To appear so that we can condone the delay. Where is your opponent?
my lords, he had appeared in serial number 121, my lords. And my lords, now the appellant has not been
Tomorrow.
allowed to draw salary for 9 months, my lords.
Inform your opponent tomorrow.
Kindly. Great.
Tomorrow is remind us, 2:30.
Kindly. Great.
41, 42 are urgent, seal number 43. Manu Prabhakar Kulkarni.
Lord, this is an appeal under section 37.
This can go up.
Please.
No longer matter now. This commercial matter will take time.
This may take a little time.
Choose your date. Immediately after you open.
Immediately after.
Lordship, then there are, my only one submission before your lordship, that there is an order on 12th August 2024, my lord, where it was directed that they will deposit 50% of the award because we have already filed an execution so that they get a stay of the award. My lord, the award has also interest component. The principal and interest at the rate of 18% per annum from 4/1/2012.
So 50% the award amount. If award includes interest, it will proportionate cost and interest.
Yes, my lord.
Lord,
So that 50%, they have only deposited 55 lakhs, only half of the principal amount. My lord. My lord, I have got judgment which says that the arbitrator has the discretion of imposing post-award interest at a reasonable rate. My lord.
Award is with interest.
Award with interest.
Then it is 50% of the award amount. It will include interest.
my respectful submission is that the reason with interest was not mentioned, in fact, is for the reason that 50% had already been deposited before the section 34 court. They made an application to withdraw that 50%. I did not oppose it. They withdrew their application to withdraw that sum. Keeping all of that in mind,
No,
lords,
there is no application as such for withdrawal.
not here, before the 34 court.
Yes, it was, there was no withdrawal application. They were,
From the order.
they have deposited that it is there.
I had deposited before the trial court way back now.
My lord.
You withdrawn?
They have not withdrawn. They have not withdrawn. They had every
We have not
opportunity
withdrawn
to
that
withdraw.
money. It is still lying. My lord, my lord, that is we have checked the records.
We do not know, then you get the clarification.
It is lying in the
Not- in
commercial
fact, they
court
mentioned
deposit.
this. Then the court said it can be heard finally.
That was,
We do not know what is the import of this 50% of the award. He says that since 50% already deposited, it is without interest.
Please.
You are saying, get the clarification, the very bench.
very well, my lord. And let it, my lord, after 10th of January, please, my lord. Well, and a date can be fixed, my lord.
20th January.
The 37 be heard it at length.
Pardon?
37 application, my lord. That will be heard in then.
Which one?
The your 37 application.
Yes, it's for the appeal only.
Huh? Okay.
20th January is for the appeals.
Hmm.
For this appeal.
Yes, 37 appeal.
Yes, that's what I'm saying.
So it will go to 20th January, both.
Please. Great.
Oblige.
Number 44, Mr. K.V. Narasimhan.
Some delay, my lord, in filing of the appeal. The Mangalore City Corporation, my lord, is in an appeal.
Lord, we have filed application for vacating the interim order granted. Objection and
Vacating interim order.
Lord,
Give
even
the
though,
statement of
even
objection.
though, my lord, there is a delay, my lord, the interim order is granted by this honor.
Has been granted subject to.
449 days delay.
Delay of 479.
My lord, subject to I making the deposit, my lord, the interim relief was granted. I have complied with the order of this honorable court, my lord, and I have made the deposit before this honorable court. But, it is the reason, my lord. Now, a money decree, my lord, has been decreed. Money suit has been decreed. Lord, the very way in which, my lord, the parties have been described itself, my lord, was defective. There is no effective, my lord, participation in the course of the trial. Virtually an ex parte decree has been passed.
So no written statement is.
There
filed.
is a miscellaneous proceedings which have already been initiated by the co-defendant, and that is coming on 17/12 before the court below. Now, these are certain things, my lord, that have taken place in the matter.
You did not appear in the proceedings?
The
They
confusion, my lord, that
they
happened
appeared,
is-
not filed written statement. They have cross-examined the witness. And then thereafter, my lord, after the
My lord,
trial,
what
my lord,
happens?
decree has been.
My lord, I'll make this submission. My lord,
Can
the
you
way
read
in
it?
which the parties have been described.
You did not file your written statement?
My lord, no, the written statement, my lord, has not been filed.
Appeal itself cannot be maintained. my lord.
Now, there is already a miscellaneous that has been filed.
How much you have deposited?
Pardon me, my lord, I have deposited.
60 lakhs.
Sixty lakhs was the direction to deposit.
There are two appeals. Lord, in 406, my lord, I have deposited a sum of rupees 60 lakhs. And in 407, my lord, I have deposited a sum of rupees 25 lakhs.
So 85 is deposited.
Please, my lord.
And what is the total amount required to be deposited?
My lord, in the first matter, my lord, I have been called upon to
How many?
pay a sum.
One
My lord,
crore 15 lakhs.
1 crore 11,95,156, my lord, was the amount, my lord, that is decreed in the first of the appeal, that is in 406 of 2024. More than,
From where we get that?
my lord, I have made a calculation, my lord, in the form of a valuation slip. I have, my lord, calculated as to the amount.
1 crore?
1 crore 11,95,156. Out of which, my lord, 60 lakhs I have already deposited.
You're 85.
Pardon, my lord?
You said 25 more is deposited. 25 further is deposited? What is
20,
it?
my lord, 25 lakhs in the next appeal, my lord.
Next appeal.
Please, in 407 of 2024, I have deposited 25 lakhs.
So this can go back?
Please.
Both, Lord, there is a delay of, my lord, 449 days, my lord. So no explanation, my lord, why there is a, my lord, so much of.
My lord, my lord, I explain this. My lord, the way in which, my lord, the parties were arrayed, my lord, is a defect. For example, my lord, for the instance, my lord, I'll just point out, my lord may kindly take 407. The way in which the parties have been described, my lord, itself is erroneous. They could not have done in this fashion. I only request this, my lord, to be
470
taken.
days delay.
My lord, I'll just, my lord, point out. Because the plaintiff cannot, my lord, make an array of a party, my lord, in a way that it cannot accommodate an effective participation. Please see, my lord, page number 16 of that appeal. I'm taking, my lord, to the cause title of the judgment and decree. My lord, they say defendant number 1 is Karnataka Urban Infrastructure Development and Financial Corporation. It's a totally different corporation. Now they say it is represented by Mangalore City Corporation, by its commissioner. Now Mangalore City Corporation is totally different from KUI SDFC. And then, my lord, they make executive engineer, my lord, the second defendant of KUIS DFC. The commissioner of the Mangalore City Corporation cannot, my lord, represent the corporation which has got its own entity and has got its own panel of counsel. Now, same way, my lord, it has been done in the first one, that is 406. where KUIDFC is shown to have been represented by the commissioner. And that is where KUIDFC has filed a miscellaneous petition and that is pending. Miscellaneous 16 of 2023 and 18 of 2024 is filed. Not substantial amount, my lord, we have already deposited. As seeking an opportunity, my lord, we'll place on record. 11 years is the delay in commissioning the work by the plaintiff. 2004, my lord, is the tender. 2015, they commission. Now they take an objection for 479 days delay. When 11 years, my lord, was the delay on their part. But I have got, my lord, certain things to be stated.
Where do you show that you are not heard and did not file written statement?
Counsel was there, they have cross-examined the witness.
How can they lead evidence without pleading?
Lord, my witness, they have cross-examined.
Correct, they could not, the judge could not have permitted to do.
They have permitted, my lord, they have cross-examined the witness.
How do you say that you are not heard?
Lord, I have not cross-examined. I have got the deposition. My
So
lord,
you
the
filed-
cross-examination
No,
has
you
been
are-
taken as nil.
Did you file your written statement?
No, in the first matter, my lord, 406, I have not filed the written statement. It has been recorded so, my lord, in the course of the judgment itself.
Show that.
My lord, page number 23, my lord. Running page number 23, internal page number 14, paragraph number 3.
Internal page number 14.
Please, my lord, running page number 23. Paragraph number 3. On service of summons, defendant have appeared through their respective counsels but not filed written statement.
Page in which matter?
My lord, in 406, my lord, 406 of 2024.
406.
They have filed written arguments also, my lord.
Page
Page 23, my lord.
23.
Paragraph number 3.
Running page 23.
Running page number 23, internal page number 14. Paragraph number 3.
So in this matter, written statement is not filed.
No.
Para 11, your lordship will kindly say it. Page 20, my lord.
Other matter?
Page 20, my lords. Same judgment, my lord, page 20. Internal page 20 at paragraph 11. The learned counsel for the demand number 2 has filed their written arguments.
Will impose some.
Lord, execution
on
petition.
higher side and
Lord,
defend.
execution petition was filed, my lord. After issuing the attachment warrant, my lord, they have filed this appeal. That too, my lord, but I am relying on the judgment of the Honorable Supreme Court, my lord, in the matter of quotas. Para 7. my lord. Paragraph 7, my lord. It's on the question, my lord, without condoning the delay, my lord, the granting of an interim order. It is on that aspect of the matter. It is to be noticed that even without condoning the delay. Paragraph 7.
how does this help you?
The interim order, my lord. Para 7, your lordship will kindly.
We are not passing interim order without condoning deal.
It's already passed, my lord. Interim order is already passed, directing them, my lord, to deposit certain amount, my lord. Subject to that, my lord, the execution, my lord, proceedings are stayed. Delay is yet to be condoned.
Will pass the orders. At least both are, in both you are not heard.
Pardon, my lord.
In both you did not.
My lord, in the second matter, my lord, I have not been shown as a party directly. Now KUIDFC is shown and then it is represented by the Commissioner Mangalore City Corporation is shown. That's where leave application also I have filed. Now, they do not make me a party and then my lord want to execute a decree against me. And hence in the second matter, an IA seeking leave, my lord, is filed.
Why you are delayed by 479 days?
My lord, the delay did happen, my lord, because of these confusions that had set in. My lord, there was a different party, my lord, altogether, who had, my lord, only filed a brief written note. And then, my lord, only in the first matter, my lord, there is 479 days delay. The second appeal, my lord, there is not much of a delay.
Confusion prevailed for.
There is 183 days delay, my lord, in the second appeal. 183 days delay. The valuable rights, my lord, are involved because of the lapse, my lord, on the part of the plaintiff who did not commission the work, my lord, he cannot take an advantage.
Right. Will pass the orders. Right.
Lord, one set of miscellaneous, the co-defendant has already filed and that is pending, my lord.
Delay appears to be very large. We have to go through your explanation. What is the explanation? Same routine.
Yes.
No, my lord, I have stated some of the administrative works,
Admin.
the ensuing elections and the onerous, my lord, is the liabilities almost to the crore, above 1 crore. My lord, there are lapses on the part of the plaintiff, my lord. One opportunity, if my lord gives, my lord, we will.
Judgment on delay on leaving media India limit.
Lord, ultimately, my lord, sufficient cause is something, my lord, that will have to be taken a liberal view of, having regard to the.
What they have said. How many? 479.
479 days delay, my lord, in the first appeal, and 183 days, my lord, in the second appeal.
Both are connected?
They are not connected. My
Appellants
lord,
are-
the
appellants are the
plaintiffs
same.
are one and the same.
Appellants and the respondents are one and the same. They arise out of two suits, my lord. Two different orders. But two different courts. Parties are same.
Because, my lord, I have stated, the miscellaneous that was filed by the co-defendant had gone to orders. At that point of time, my lord, an application was filed by the plaintiff seeking recall. From that stage, my lord, the miscellaneous proceedings was recalled and the matter was taken up, my lord, for consideration. Now on the arguments, my lord, the miscellaneous is posted on 17/12.
On 13th we'll take it. 13th to 3rd. You, both you reading, both.
Please. Interim order may kindly be extended.
number 46. So suddenly,
Please. This is not a petition in public interest. Forest land notified to be forest land. An order was proposed to be issued at Annexure A to dispose of that forest land without denotifying the forest area. Not the state in their principal counter do not seriously oppose the writ petition. They don't seriously dispute that this is forest land. But will your lordship please see, my lords, to the writ petition Annexure B is where the declaration as to forest commences, and this page 51, my lords, is Annexure B. This is during the Mysore government. Under the provisions of section 9 of the Forest Rules, 1878, the government of Mysore is pleased to declare the undermentioned demarcated and settled plantations in Bangalore, Kolar and Tumkur districts shall be classed as government plantations under Rule 1 of the aforesaid Forest Rules. The relevant portion your lordship will please find at page 57. At page 57, my lord, serial number 38. Lordship will please see, my lords, it says Macho Halli and Macho Halli A on top. This is 270 acres of Macho Halli plantation, which is declared as a plantation or a forest area. This is the first notification. Macho Halli and Macho Halli A, my lords, 270 acres.
My lord, could this be taken up after vacation, my lord?
Please, my lords, there is an interim order.
So what is the PIL for?
My lords,
They did not oppose the release of the land.
lords, at Annexure A, they initially passed an order to allot this forest land for non-forest purposes without taking clearance under section 2 of the Forest Conservation Act. Annexure A at page 28, translated copy, my lord, so lordship will please find at page 34. This forest land, my lords, was sought to be allotted to various institutions without seeking permission of the central government under section 2.
So that is the subject matter of challenge.
Please, my lords.
So it is admittedly a forest land.
Lords, in their counter affidavit of 31/7/2018, they don't seriously, the state, my lord, seriously does not dispute that this is forest land. In para 5, my lords, of their counter, they say in para 4, my lords, they admit the notification of their counter.
It is the affidavit dated.
Lords, 19/8/2019. Statement of objections on behalf of respondent state.
19/8/19.
Please, my lords, 19/8/2019.
Yes.
In that, my lords, your lordship may please see from para 2 onwards. It is respectfully submitted that the order dated so and so Annexure A, the government has leased an extent of 58 acres, 20 gunthas of survey number 81 of Machohalli village, Dasanapura Hubli of Bengaluru urban district to 36 organizations and 19 acres, 20 gunthas of the said survey number for public purpose under the Karnataka land grant rules. The said lands fall within the Machohalli reserved forest. Vide notification dated so and so. This is, my lords, Annexure C, the document they're referring to, the notification. The Machohalli and Machohalli A blocks were classed as government plantations by Government of Mysore under provisions of section 9 of Rules of Administration of Forests and Wastelands in the territories of His Highness the Maharaja of Mysore 1878. Vide notification dated so and so. This is Annexure B. This notification was published in the Mysore Gazette so and so from 171 to 182 of the notification. Subsequently, these government plantations
This is
were.
what you read, same.
Please, my lords. Therefore, my lords, my respectful submission is until and unless they say that there is a notification declaring this forest as deforested.
Denotify.
There is no such notification. They don't say so. In fact, my lords, in para 7, it is further submitted that it is true that the Deputy Conservator of Forest, Bangalore, addressed a letter to Deputy Commissioner Bangalore, has requested to give directions to concerned revenue officers to mutate survey number 81, which forms part, to hand over Machohalli Reserve Forest to Forest Department. And in their final prayer, my lords, unless I am reading it wrong, they say, wherefore it is respectfully prayed that this honorable court be pleased to dismiss the above writ petition with the direction to hand over Machohalli Reserved Forest to Forest Department in the interest of justice.
You really need time.
My lord, I need time. I apologize, my lord.
It is very old matter, no? Of which year? 18.
2018.
16th of
Please.
January.
Please.
Obligement.
At the request made by learned additional government. Srimati Neelofer. Something is filed or not filed? This is the only file.
My lord, I've been given a very small file. my
Very,
lord.
very.
Great.
No, I'm not going to open the file.
Number 47.
Your Lordship,
This again.
Your Lordship, I am the petitioner in this case, my lord. Am I audible, Your Lordships? Your Lordship, this is a PIL filed against a notification issued by the state government prescribing fares for the taxis. And the taxis are classified according to the cost of the vehicle, and the notification itself doesn't define what is the cost of the vehicle, Your Lordship. Annexure A. English version is at page number 21, my lord.
Taxi charges.
Yes.
Taxi, my lord.
This can wait. February.
The Lordship, right from 2018, these illegal notifications are being in force, Your Lordships. And all the general public is gullible, the general public is
Will consider February 14th.
February 14th, Your Lordship.
Yes.
Obliged, Your Lordship.
Number 48.
My lords, I appear for the petitioners. My lord, I have filed an additional. My lord, this is a forest land. My lord, I have produced the photographies of the forest area. My lord, this was now has been.
Better come physically so that it's pleasure to listen to your arguments. So let it go to January.
Lord, ma'am. My lord, there is a threat of cut and remove the trees. My lord, Your Lordship. That is how I have the.
It is an old matter. We'll keep it on 13th January.
Lord, may I seek Your Lordship, it is for interim order, my lord, not to cut and remove the tree till then.
On that day, we'll consider.
Number 49. Ramesh Chandra.
I appear for the petitioner, my lord. I have both the respond number 15 and 24 were not served. That's why I filed an application seeking paper publication, my lord.
This is going for the 16 and
15 and 24, my lord. Thrice I have taken steps it was not served. That's why I have taken up steps by application, while an application seeking paper publication of to serve them, my lord. Sorry, my lord, I was there and immediately some urgent work came, that's why I came into office, my lord.
Here is, my lord, to close down all commercial establishment on that road.
You file the reply.
No.
File reply. Reply shall be filed before the next day, put upon 18th February.
May I take the notice, my lord?
Notice.
Notice.
Notice to the unsought respondent. Press notice to the unsought respondent. Returnable on the same date. Next.
Number 50, Mr. Dhananjay Kumar.
Appearing for the petitioner, Your Lordship. Your Lordship, we have filed an IA for restoration of the writ petition which was dismissed due to non-compliance of office objection.
IA number
IA number 2 of 24.
2 of 24 with IA number 3 of 24.
Subsequently, we also filed IA number 3 of 24 for condonation of
Just,
delay.
Order in IA number 3 of 24. This have heard learned advocate for the applicant. This application is filed seeking delay of 111 days, which has taken place in filing the restoration application. Full stop. The delay is to be viewed leniently in as much as the litigant is required to given a chance to contest his case on merits. In that view, delay is gone down. As sufficient cause is made out, application is allowed. Then order in IA number 2 of 23, heard learned applicant. This application is filed seeking restoration of the writ petition which was dismissed for want of prosecution on the ground that the office objections were not removed within stipulated time. Learned advocate for the applicant stated that whatever office objections are left out from being removed shall now be removed, within the time which may be granted by the court.
We will comply the office objection within a week time.
Full stop. In view of the above readiness shown and further in view that the appellant is not thrown out on the, it is appeal. Petition is not thrown out on the technical ground of non-removal of office objections, the petition is restored to its original file along with the subsisting orders therein on condition, however, that whatever office objections are to be removed shall be removed within a period of 3 weeks from now.
3. Much obliged.
So both are at 22. CSR.
51, Mr. Krishna S. Vyas.
For the accused 1 to 4 minutes.
Respond number 1, my lord. As per respond number 2, my lord. As far as respond number 2 is concerned, it is not coming under jurisdiction of National Highway Authority of India. That notification issued by the PW Department, state government.
Who is your opponent?
Petitioner.
Mr. Krishna N. Vyas.
Then after vacation, 15th February. Awaiting in 15, stand out to 15th February, awaiting in vain the presence of, not 15th, 17th February. Awaiting in vain the presence of learned of the petition. Next.
Thank you. Oh, 17. Okay, I took it.
The pass over matter, seal number 119. I appear for the appellant. Lord, I am filing the memo for the withdrawal. He is also present before the court. Party is also present before the court. Same may be recorded.
So what do you?
If they want to file civil suit, let them file, please. Liberty, I oppose for liberty,
That you can.
because there is no land, please.
Second. In course of the hearing of the rate appeal. Learned advocate for the appellant files memo dated 1/9/2024. Full stop. Paragraph. The memo reads as under, then court dismiss. In view of the memo, appeal is pardoned to be withdrawn, dismissed as withdrawn. Full stop. Liberty. The appellant may file civil suit if so advised. However, this court does not express any opinion on the merits of the case, including the merits of the civil suit as well as the very recourse to be taken in that regard.
Much obliged.
They have already exhausted that remedy. They withdrew the suit in the year 2021
Yes.
itself.
No, my lord, you have not
With
filed
respect to
it.
same land.
This will be.
Much obliged. Bill number 52. Complaints in contempt matters.
This contempt
So
petition,
Mahesh
sir, is
Atkal court?
directed against the interim order of lordship. Merged with the final order of lord, writ petition came to be disposed of, against which appeal was filed, appeal came to be dismissed, against which second round writ petition was filed, in that interim order has been granted, my lord. This becomes virtually infructuous, your lordship. This contempt petition is filed against alleging violation of the interim order of lordship granted in the writ petition. The writ petition finally disposed of, your lordship, giving liberty to us to file an appeal before the competent authority. We filed an appeal before the appellate authority, my lord. We got the interim order in that, my lord, till the disposal of the appeal. Then finally appeal came to be dismissed. Then we filed a writ petition before this honorable court. This honorable court granted an interim order, my lord. Therefore, the contempt petition filed, my lord, is become infructuous.
Where is your counterpart?
Last occasion also the matter had come up.
Let it go to 8th of January.
Bill number 53. So Raghunath MD.
I appear for the complainant, my lords. This
Appear
complaint,
on
my
behalf of
lords,
the respondent in this case, my lord.
is pertaining to the contempt where the respondent or the accused has not followed the directions passed by the Honorable Trial Court, my lords. If I may bring to my lord's attention to ink page number 32 at Annexure D. This is the first order passed by the Honorable Trial Court, Family Court, pertaining to the visitation and the contact rights to the complainant, my lords.
Yes.
It starts from ink page number 31, my lords. On 8/8/2022. If my lords may kindly peruse the next page, that is ink page number 32. It says, issue notice to the respondent through mail if PF paid and copies furnished. Moreover, as per endorsement of the office on so-and-so date, respondent refused to receive the notice sent through court. Advocate for the petitioner prays for an urgent hearing, so-and-so, heard and perused. In the interest of justice and equity, pending disposal of IA number 2, the petitioner is granted visitation and contact rights as under. The petitioner shall have access to the child by name Shivansh Yadav, aged about 4 years, who is in the custody of the respondent. He can meet the child on every Saturday morning from 9 a.m. to 12 noon. And he can talk with the child through phone and WhatsApp video call every day for 15 minutes between 5 p.m. to 6 p.m., my lords. This was the first order passed, my lords. Subsequently, there has been a non-adherence of the order. Hence, if my lords may kindly peruse at ink page number 39. Respondent is absent, my lords. Subsequently, at ink page number 40, considering the submission of the advocate for the petitioner was not allowed to exercise his right of visitation to see the child. Therefore, Respondent is directed to bring the child. If it is not possible, the respondent should produce necessary documents where the child is studying. Call on the next date, 11/8/2023. On the 11/8/2023, my lords, both the parties and the councils are present. A memo filed with enclosures. Conciliation also held. Respondent is residing in Bengaluru, but child is residing with her father in Madhya Pradesh, where petitioner was denied visitation rights. To enable the petitioner / father to exercise his visitation rights, the respondent is directed to bring the child on 11/9/2023. Henceforth, subsequently, my lords, on all the other occasion and dates, the respondent or the accused had failed to even exercise the contact visitation rights. For that, if I may be permitted to furnish the documents, my lord, showcasing the WhatsApp video call history between the complainant and the respondent, my lords.
Your mother.
I am for the father, my lords.
Father.
If I may make
How it
one,
can be enforced?
if I may make one respectful submission at this juncture, my lord. My lord, if I may invite my lord's attention. If I may invite my lord's attention to page 5 of the writ petition, my lord. The complainant herein has conveniently omitted certain aspects which has happened over the course of this particular litigation, my lord. If I am permitted to read para 11 onwards, my lord, of the writ petition, the complainant begs to submit that to this honorable court, due to such willful disobedience of the order passed by the honorable trial court, the accused was directed to hand over temporary custody of the minor child to the complainant on 12/10/2023. My lord, this particular order dated 12/10/2023 was challenged by the respondent accused before this honorable court, and the learned single judge has set aside this particular order. My lord, this particular petition, this particular contempt petition was filed on 12th June 2024, my lord. And the writ petition that I am referring to, in which the order dated 12/10/2023 was challenged, was filed in the month of April, my lords. And there was also a stay order operating as against the order dated 12/10/2023. Conveniently, by omitting all those essential aspects, the complainant herein has filed this particular contempt petition, my lord. If I may invite my lord's attention to my affidavit that I have filed, my lord. The counter affidavit that I have filed, my lord. If I may invite my lord's attention to page 97 of my affidavit, my lord. Are my lords there? If I may be permitted.
Where is the affidavit?
The affidavit, I filed it on 19 September 2024, my lord, to this particular contempt petition.
Yes.
If I may request my lords to kindly come to page number 97 of my affidavit. This is the order that was passed by the learned single judge when I challenged the order dated 12/10/2023, my lord. My lord, that I had challenged IA number 8, my lord. The very prayer in IA number 8 was such that they had alleged both contempt and they had also sought for permanent custody of the child. Even if I may invite my lord's attention to the prayer that is made in this particular contempt. If I may invite my lord's attention to page 6. They mention that allow the above petition take suitable action against the accused for violating the orders of the Honorable Trial Court in GNWC number 156 of 22 on the file of 6th Additional Principal Judge Family Court at Bengaluru. My lord, at no point of time do they mention as to what is the willful disobedience, and they have not demonstrated any kind of willful disobedience, my lord. And one more thing that I would like to point out to this honorable court is that, my lord, after this particular writ petition was allowed by the learned single judge, if I may invite my lord's attention to page 104, my lord, the operative portion of the order. The order impugned, if I may read.
Where is
104, my lords, of the counter affidavit. If I may read, my lord. The order impugned dated 12/10/2023 passed by the 6th Additional Principal Judge Family Court Bengaluru on IA number 8 in GNWC number 156 of 2022 is set aside and the matter is remanded back to the trial court. The petitioner wife shall file her objections to IA number 8 within 10 days from the receipt of the copy of this order. The trial court shall pass appropriate orders within 2 months from the date of receipt of this copy of this order. Accordingly, writ petition stands disposed of. My lord, I have advanced the matter. I have filed my objections. I have argued the matter before the trial court, and I have also filed my written arguments. On the contrary, my lord, the complainant, the counsel on behalf of the complainant has not at all been appearing before the trial court. And I'm also told from November 30th, 2024, he has not even been practicing the visitation rights that is awarded to him under IA number 2, my lord. While all of this is the situation, my lord, the matter was posted before the trial court on 2/12/2024 when the counsel on behalf of the petitioner, that is the complainant herein, had not even appeared. We have filed our objections. We have filed our written arguments. We have diligently complied with the orders of this honorable court. And despite that, they were not turning up before the court merely to postpone the proceedings, my lord. Upon our insistence, the Honorable Trial Court has posted the matter for 6/1/2025 to pass orders on IA number 8, my lord. That is the same IA which was remanded back by the learned single judge in this particular writ petition, my lord. We have been diligently practicing we have been diligently following the orders of this honorable court, my lord. At one point of time, we were not able to comply with the orders due to the fact that both the respondent's father as well as mother were under critical care, my lord. In fact, if I may pass on this particular medical records, my lord. Court officer.
May I make a humble submission, my lords? As per the statements made by my learned friend, at ink page number 103 of the counter affidavit, I would request my lords to peruse para number 7, my lords. That is the observation made by the learned single judge, wherein there is a clear contempt, my lords. If I may bring to my lord's attention to ink page number 103. There, at para number 7, last but 2 sentences, my lords. When a court passes several orders, at ink page number 103, my lords, last but 2 sentence, when a court passes several orders, she fails to obey them, and again she comes up before this court seeking the relief. This conduct and the attitude of the petitioner/wife cannot be appreciated. The trial court shall not grant unnecessary adjournment in this case. If this is the kind of attitude and disobedience is exhibited by the wife, the trial court shall look at it seriously and pass appropriate orders. My lords, despite my learned friend bringing knowledge before this honorable court pertaining to IA number 8, which is nowhere concerned to the present contempt petition. My contempt petition is based on two orders, which is at ink page number 32 on 8/8/2022, as well as the subsequent order on 11/8/2023 at ink page number 40. This has nothing to do with the IA number 8. I don't understand why my learned friend is bringing IA number 8 before this honorable court. Even otherwise, if the same has been brought up before my lords, there is an observation that the wife petitioner, who is the accused before this honorable court, has not been complying with the orders. That is why IA number 8, the honorable trial court, had to pass a very stringent order, if I may bring to my lord's attention, to my contempt petition at ink page number 40 itself, my lords. And the stringent action taken by the Honorable Trial Court is at ink page number 42 at Annexure E. And that, my lords, the said documents given by this learned counsel before my lords is pertaining to all the calls made by the complainant to the accused father as well as the accused, and none of it, my lords, if my lords may kindly peruse from ink page number 24, from the said document which my lords have been perusing, it has clearly been seen, my lords, despite there being outgoing calls from the complainant, it is always not answered. They have diligently and deliberately not answering to the calls made by the complainant at every single instance. As this honorable court may kindly recollect, the order passed by the honorable trial court, every day between 5 to 6, a WhatsApp video call could be made by the complainant. Despite doing so, it has been unanswered on every single date, my lords. Even if they do answer, I may bring to my lord's attention to ink page number 98 from the said document. My lords may kindly peruse the screenshots, the photographs. The child has not been shown. Ink page number 98, my lords. First of all, they don't answer the calls. Even if they do answer a call, this is the screenshot that the complainant has furnished before my lords. There is no contact rights, my lord. They do not show the child at all. That's a deliberate kind of a contempt being followed and made by the accused, despite the complainant being the father.
If I may make one respectful
This
submission.
is the state of the situation that's happening, my lords. Anything is done, they do not come about on this aspect. Rather, they try to defend and deny it. And these are the screenshots on every occasion which the accused's father has answered the call. And at every instance, my lords may kindly peruse, the child is not seen. Where is the question of even interacting, my lords? The Honorable Apex Court was very clear that the father and the mother both have a right to interact. When the mother has the custody of the child, the father should be given a contact rights. That is what I'm seeking for.
My lord,
that also has been denied.
if I may make one respectful submission, my lord. If my lords could see the timestamp on the 98, 99, whatever my learned friend referred to, it is literally one isolated incident, and it clearly mentions 5:30, 5:37. The screenshots have been taken in one single call, and they are trying to portray it in such a manner that we have not been giving contact rights at all. And my lord, the minor child is a toddler. We can't hold him, control him in any manner, my lord.
Sorry, that is wrong. That is a wrong submission.
It is not. He is a
They do
toddler,
not
my lord.
give me an
It is my
opportunity.
respectful submission that it is an isolated incident which they're trying to portray in a larger manner, my lord.
Let my lords take cognizance of this act. At least it could be had on the next day, my lords, tomorrow.
We'll see. Possible. Any other day. One second. Yes, and what is it?
My lords, at least
86, my lord.
Which one?
86.
18.
86.
86.
Please.
What is it?
But the section 9 petition, my lord, the commercial court before the Mysore has refused interim order. It can be taken up at tomorrow at 2:30, my lord.
Right, serial number 55. 55.
Must have
I appear for the husband who is presently in the United States of America.
The family court grants him an opportunity to interact with his children through WhatsApp video call by way of a mandatory order. Mother is not cooperating. It's for that reason we have filed contempt. Lordships could have it on Wednesday, my lords. Because the reason is this, my lord, he is not able to access to his children. That is all that he's asking is that through a WhatsApp call. There is a direction by the court.
Time, there will be no time.
But this is something more, it's a human issue, my lord. Father's affection towards his children. It's only for that reason I'm mentioning, but if not, nothing else.
Who appears?
Please.
Who will appear?
The
Bindu.
Bindu.
Lordship, Bindu. Advocate Bindu is for the.
Next witness, please.
Serial number 90, my lords, your lordship had posted it today. Serial number 90, but it did not.
Tomorrow. Two more.
Please.
Please. My lord, serial number 64. Lord, in that, the office objection is in the LR application, full cost title to be furnished. The office objection is that full cost title to be furnished in LR application, my lord. I have filed the LR application for the complainant. That office objection may be waived, my lord. I will be permitted to come on record, my lord. Only full cost title to be filed is the office objection on the IFR LR application, my lord.
Will you say that it is complied with?
I'm seeking dispensation, my lord. Full cost title may be dispensed. That's all, my lord.
Dispensation for?
The objection, the office has raised an objection in the LR application. I have to mention the full cost title of the petition. Small cost title is mentioned. Therefore, that may be waived off. I may be permitted to come on record as LRs of complaint.
The application you have to mention the full naturally. Otherwise, how will the notice will go and how will identify the parties? Small office, remove it.
My lord, serial number 65, Your Honor. Past three times this matter has not been reached. Matter number, item number 65, Your Honor. The matter has not been reached for last 3 times.
65, we have issued an endorsement, my lord. 65, an endorsement has already been issued to the complainant. And against that endorsement, they have now filed a counter affidavit saying what the endorsement given by us is not correct. But it was only for consideration.
Any short accommodation to argue the matter.
It is complied with.
Please comply.
16th at 2:30.
Muchabli.
Serial number 83, Your Worship, is surface matter. Single judge has directed the parties to approach the DRT. Instead, he has approached the report. And
now after vacation.
Your Worship, he is due to about 78 lakhs. Yes, he is due to the bank to about 86 lakhs. And he was directed to approach the DRT. Instead, he has approached this court.
My lord, serial number 53 could have had tomorrow.
Serial number 53.